He offers that position to the appellate division. Draw near, give your attendance, and that shall be heard.
Good afternoon and welcome to the Appellate Division First Department. My cheat sheet here tells me that we have 8.5 hours of argument scheduled. So assuming nobody wants to be here until 10:30 tonight, I would ask that you please ask just for the time that you need, remembering that we have had your briefs and your records and we are familiar with the cases. We would just like to ask maybe a few questions and have you hone in on your most important points. So with that being said, let's call the calendar. When I do, please, everybody on that case stand up and tell me how much time you're requesting. On People versus Aviles. Are you the appellant? 3 and 1, and respondent? 3, 1, and 4. Thank you. Candelario versus MJHS Hospice. Okay, and okay, 5, 2, and 5. Thank you. M. Victor versus Adriana Y. You are whom? I'm the respondent. You're the respondent father? Yes. Okay. It appears that nobody else is here. Would you like to just submit?
Yes. Well, wants me to stay for some questions. It's up to the court. The court wants me to stay for some questions. I'll stay. If not, I'll submit.
Everybody okay with the submission? Okay. Thank you very much. Just have a seat till the end of the calendar. Thank you, counsel. Matthew versus DeRose. Respond. Okay, we're going to do 6 and 2 and 6. If we have additional questions, we'll keep you going, I promise. Peter Green versus NYU Lancome. Appellant? 5 and 2, okay.
Respondent request 7.
Okay, I'll give you 5, 2, and 6. Thank you. People versus Dennis Martinez. And respondent?
6, Your Honor.
Okay, 6, 2, and 6. 63rd and 3rd. I understand that that's going to be submitted. That's the respondent is not here. I think we were okay with this case, so we'll mark it submitted and if just have a seat till the end of the calendar. Thank you. Hockaday versus Hessel.
Defendant's appellants respectfully requesting 5 and 1, Your Honors.
Okay,
Respondent 5 minutes.
you got it. 5, 1, and 5. OKL Holdings versus Abercrombie and Fitch.
Good afternoon, Judge. These are 2 appeals. So I request 10 and 3.
A respondent?
5 and 2, Your Honor.
Do you have your own appeal? I don't think so. You're not an appellate. Okay. First of all, okay, I'm going to give you 6 and 2 and 6. Thank you. People versus Samuel. Respondent? 6, 2, and 6. Thank you. Bayman Industries versus Empire City Subway.
Respondent request 5.
Okay, 6, 1, and 5. Thanks. Lamar versus Nigro.
Good afternoon, Your Honors. I respectfully request 5 and 2.
Okay, and respondent?
Request 5 minutes.
Okay, 5, 2, and 5. People versus Swinton. Submitted. Kralik versus New York City Department of Housing. 5 and 2, and we have, you represent whom? HPD is Tri-Faith here? No. Okay, how much time are you requesting?
4
Okay, 5 and 2 and 4. Thank you. Dong versus Cruz Marte.
Good afternoon, Your Honor. Dong Cruz Marte, respectfully requesting 5 and 2.
Okay, and the other appellant?
Good afternoon, Colin Keystone Fraser, I will transport 2 minutes, please.
You want 2 minutes? Okay. And the respondents? Okay, and the Sung? Okay, so if I'm right, 5 and 2 and 2 and 4 and 2. Okay, thank you very much. Hunt versus Cube Smart. Respondent. The appellant does not seem to be here, per se. So would you like to submit?
Unless there are other questions from the court, otherwise I'll do 2 minutes on that.
You want to do 2 minutes? Okay, if you want to do that, that's fine. All right, 2 minutes for the respondent. Manson from Pong versus Forbes.
For the plaintiff, 5 and 2.
And respond? 5 and 2 and 6. Okay, thank you. Jones versus Renato, New York. That case I understand is being submitted. People versus Williams. 4 and 1 and respondent. 4, 1 and 4. And the last case, Ardell Construction, is submitted. So, thank you very much. The first case for argument is People versus Aviles. Okay, good afternoon, and you may begin.
Good afternoon, Your Honors. Ashley Baxter, Legal Aid Society, on behalf of Nelson Aviles, and may it please the court. Your Honors, the SORA court erred in denying Mr. Aviles' request for a downward departure to risk level 1 in light of his age, the remoteness of the underlying offense, his successful reintegration into the community 17 years since completing his sentence for this offense, and his...
Why was that an abuse of discretion?
Well, Your Honor, he demonstrated mitigating factors. First, he has shown that he has rehabilitated. He's been in the community for decades without further sexual reoffense or otherwise contact with the criminal justice system. This offense occurred between 86, 87. He has married and had a child. He's been gainfully employed. He completed his sentence over 17 years ago, and he's currently 62 years old, where he's at a much lower risk of reoffending. In addition, he has extensive participation in sex offender treatment for 8 years, and it's been almost 4 decades since this offense, and Mr. Aviles has shown that he is capable of leading a law-abiding life and would very much love to move forward. He's currently working at a warehouse but unable to get better employment because of his status on the registry. For the foregoing reasons, we ask that Mr. Aviles be adjudicated risk level 1, if the court has any additional questions.
Okay, thank you. We'll hear from the other side, and you'll have a minute to respond. Thank you. Good afternoon.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that this court affirm the SORA court's order adjudicating the defendant a level 2 risk. The SORA court did not abuse its discretion when it made that determination. The SORA court took into account the defendant's living and employment situation. The defendant was diagnosed with pedophilia, and so he was mandated to do 8 years of sex offender treatment, which the board outlined in its case summary that he was credited with acceptance of responsibility under Factor 12 of the RAI. The defendant committed an egregious act here by penetrating his 13-year-old brother's anus with his
That
penis.
was over 30 years ago, right?
Excuse me, Your
It was
Honor?
over 30 years ago, right?
Yes, Your Honor.
So should that be taken into account, the amount of time that's passed?
No, Your Honor. I mean, it is a sympathetic argument that the incident happened a very long time ago. However, that does not lower the defendant's risk of reoffense. If anything, the board's guidelines indicate that the younger the defendant is, the more prone he is to reoffending. The defendant was 21 years of age at the time that he committed this offense, and the board outlines in Factor 8 that if he was 20 years old, he would have been accredited with 10 additional points.
Did the board take into account the fact that at some point, even though he was never charged, there were several other victims that he spoke about at that early, from many years ago, in
Yes.
addition to the half-brother?
Yes, Your Honor. It's important to note that the RAI did not account for those additional 3 female victims because he wasn't charged with those victims. And so it is important to note that it is an aggravating circumstance that the court adequately considered when it made its determination to adjudicate the defendant a level 2 risk. And so based on the totality of the circumstances, in addition to the severity of the defendant's conduct weighed against any mitigating circumstances that the defendant presents, the SORA court properly adjudicated the defendant a level 2 risk and declined to downward
To
departure.
be clear, the RAI had him at 75 points, right?
Yes,
Which
Your
was
Honor.
presumptive level 2. And this was defendant's application for a downward departure.
Yes, Your Honor, that is
So
correct.
So that a lot of other factors come into play in whether or not the SORA court actually grants a downward departure, right?
Yes, Your Honor. And so the court addressed all of these mitigating factors or any mitigating factors that the defendant already presented. Most of the factors that the defendant discussed were already accounted for by the RAI.
Well, in terms of the treatment, I mean, we don't even know if he completed his treatment, correct? I mean, the record is there. I mean, he makes that point. And then the other thing about his age, which is not really a basis to reduce or basis to do a downward departure on age.
Yes, Your Honor, that is correct. And the defendant was still accredited with those, without those points for the acceptance of responsibility. And so if Your Honors have no further questions, we respectfully request that you affirm the SORA court's order.
Thank you.
Thank you.
In addressing the pedophilia diagnosis, Your Honors, the board's case summary notes that there is no evidence of a more recent evaluation corroborating this diagnosis. And the board noted that given this lack of documentation, it's not clear that pedophilia is still a factor. And regarding the 8 years of sex offender treatment, we noted in our brief that, as case summary pointed out, it's not clear if he completed, but extensive participation in sex offender treatment, we note is a factor for downward departure. And
We
then,
don't know, unless I missed something, we don't know in the record whether what the success or what the ratings were with respect to his treatment, do we? I mean, I didn't catch that.
that's correct. There was no documentation.
No documentation, so, I mean, this is what's presented at the SORA court. Okay, thank you.
Thank you.
Thank you. Thank you both. The next case for argument is Candelario versus MJHS Hospice.
Good afternoon. May it please the court. My name is Samantha Quinn. I represent the St. Barnabas defendants in this matter. This is a case involving alleged misdiagnosis of cancer based on, against my clients, an ER visit which occurred over less than 24 hours in 2014. Plaintiff actually mistakes two former defendants, Dr. Anan and Hospice of New York, as being part of the St. Barnabas defendants. In fact, St. Barnabas defendants are the lone remaining defendants after nearly 15 other parties have been either discontinued or settled. Because the acts of Dr. Anan actually break the causative chain between the acts of the emergency department and the subsequently alleged damages, there can be no proximate.
So is causation your best argument? That's what you're really arguing here? Because I mean, you do argue the standard of care too.
I believe the standard of care was absolutely met, and I believe we established that, but proximate
So let me
cause is
ask you about, just
abundantly
going back
clear.
to standard of care.
Yes.
Fundamentally, there seems to be an issue here as to what was reported with respect to the diagnosis, stage 4 pancreatic cancer or not, correct?
Yes.
How can we make that, without knowing, or that factual determination has to be made by a jury, correct? Before we can get to the standard of care, or am I wrong about that?
Well, first of all, Your Honor, I mean, there were many misrepresentations in the record as to what the testimony was. Dr. Winograd was the attending physician in the emergency room, and he testified that he would not have indicated stage 4 pancreatic cancer unless that had been told to him by the patient. The only
So
testimony—
you don't think there's an issue of fact about that? That we should accept that representation, that in fact that was conveyed to him, despite the fact that the plaintiff is saying something different?
I do believe that it is almost incredible testimony that this was not what was reported. The patient came in with a presentation that was consistent with stage 4 pancreatic cancer. The doctor testified that he would not create that information. This is the record at page 1284 to 1285. And when asked directly, if a patient came into you and said, I have a history of pancreatic cancer, would you then, in accord with the standard of care, write that the patient had stage 4 pancreatic cancer? I would not. Dr. Winograd said the only basis upon which he would have recorded that was if the plaintiff had told him. And supporting that also is the fact that—
And there wouldn't have been any obligation on the doctor to do any checking other than to accept what the plaintiff said, that
Well,
he had
what
stage 4
you have to
pancreatic
appreciate
cancer?
here is that this is a less than 24-hour emergency room visit. What the record reflects is that the family members, 2 women, notably the niece and another female, were there requesting that he be transferred to palliative care. What Dr. Winograd did was he made a referral to, asked for a consult from palliative care, which was Dr. Anan and Hospice of New York.
Right.
They're an entirely different entity. They came down, they assessed the patient, they decided he should be admitted to palliative care. But what is critical here, putting all this aside, so even if the court were to find there's an issue of fact, less than 10 days after these events, Dr. Anan speaks with a doctor at the Ralph Lauren Cancer Center, and I quote, as per her, the diagnosis of pancreatic cancer is not clear. They had seen dilated pancreatic duct on imaging and had suggested further studies of MRCP and tissue diagnosis. However, the patient was non-compliant. He was told to follow up and did not attend these appointments. Dr. Anan also learned that the patient hadn't gotten chemotherapy. This is on July 22nd of 2014. Despite this, Dr. Anan doesn't follow up on that information, and he later testifies that that wasn't conclusive for him, that because the patient was homeless, he did not want to discharge him to the streets, and then he said he will keep him in hospice.
I'm sorry, how do you refute that he would not have entered into hospice in the first place but for this diagnosis of stage 4 pancreatic cancer?
Well, first of all, we dispute the fact that he was diagnosed in the emergency room. Emergency rooms don't
Right, but
diagnose.
we're assuming for the purposes of my question that there's an issue of fact, because the plaintiff clearly did testify that he never said he had stage 4 cancer, and it's nowhere in the record does it say, hey, he said he had stage 4 cancer. So assuming that, just for purposes of argument, there's a question of fact about that, my question is specifically as to causation. But for this allegedly inaccurate diagnosis, isn't it true that he would not have otherwise ended up in hospital?
Your Honor, no, it's not. What happened on July 22nd is an intervening, superseding act, and what happened, if you want to say that the actions in the emergency department created an issue of fact as to the liability of the St. Barnabas defendants, we'll take that and say that this just simply furnished the occasion for, but did not cause an unrelated, unforeseeable, unanticipated event, which was this subsequent failure to follow up on this critical information and then to admit this patient to another hospice where he remained for 18 further months.
Okay, let's hear from the respondent. You'll have a few moments for rebuttal. Thank you.
Thank you, Your Honor. Good afternoon. My name is Annette Hasapitas, appearing for the plaintiffs in this case.
Can we go backwards? Can you respond to the causation argument that there was an intervening act
Yes.
which caused this damages, which is that the plaintiff stayed in hospice for a very, very long time, and that there were many opportunities along the way for other people to discover that he didn't really have stage 4 pancreatitis?
Well, first and foremost, that argument was not raised until the reply brief. Was not raised in the main brief. I didn't address it in my opposition. It was raised for the first time in the reply. It's purportedly raised in response to a couple of sentences in the respondent's brief that were providing context for the actions of the physicians. You know that when a provider wants to make a referral to hospice, they have to confirm a diagnosis. And from that spawned the superseding cause argument. So I would ask that the court not address that because the plaintiff hasn't been given an opportunity to address it. The entry by Dr. Winograd at 2:43 p.m. in the record is the error upon which all of the subsequent errors are based. But for that statement in the chart, stage 4 pancreatic cancer and cachectic, this individual, this plaintiff, would not have received a referral to hospice care. It is undisputed that you cannot receive a referral to hospice care without a stage diagnosis of a terminal illness. And it is based upon that my client spent 18 months in hospice care. The plaintiff submits, and we raise the issue below in opposition to summary judgment, that the defendants never met their burden of proof in the first instance. They attach the plaintiff's deposition testimony, but their expert affirmation makes no reference to the fact that the plaintiff said, I never told them what stage I had. I mean, the first two entries in the...
Actually, that is a technical question I do have. If there's a disputed issue of fact about what the plaintiff did or didn't say, do they make their prima facie as opposed to raise a disputed issue of fact when they say, this is what our records indicate that he didn't have?
Correct. Your Honor, you're correct. They do not make a prima facie.
No, I'm asking. I'm not telling you. I'm asking you, do they make a prima facie by the statement that we would not have put in stage 4 except that the client told us that? There's no way we would put down stage 4 on the records.
Well,
why isn't that enough to at least make a prima facie in their plaintiff's statement to the contrary, raising an issue of fact?
Because they attached plaintiff's deposition testimony to their summary judgment motion. So they proffered it in support of their motion. They present conflicting evidence, and as a matter of law, a movement who presents conflicting evidence cannot make out a prima facie. But let's cut to the chase here. Let's just, even if you want to assume that my client, or that you could accept the testimony, and Dr. Winograd's testimony is as clear as mud about the source of the information of a stage 4 diagnosis. When he's initially asked about this,
He points to the nurse's entry, right?
he points to Dr. Price.
Oh,
He says, Dr. Price first told me that 1304 and 1305 of the record. He's first asked, what's the source of the information? Dr. Price got it from the plaintiff. I copied Dr. Price, is essentially what he says. Then the attorney questioning him says, let's look at Dr. Price's entry. Oh, Dr. Price only says pancreatic cancer, HPI, pancreatic cancer 2012. Then he says, well, then the patient must have told me. So he's not unequivocal. He initially says, I copied the earlier entry. The earlier entry doesn't say that. When he's faced with that inconsistency, he says, well, it must have been the plaintiff.
And of course, he doesn't have personal knowledge about that.
He has no independent recollection, which you can't
wouldn't
fault.
expect.
Exactly. No one ever expects an emergency department physician, let alone at St. Barnabas, to have an independent recollection of this kind of a conversation years after the fact. There's no issue there. But I'm sorry, Your Honor.
So just with causation, I think that causation may be a stronger argument because what happened in hospice care, there were so many opportunities to determine, in fact, that your client, in fact, didn't have stage 4 cancer. Does that break the chain of causation?
First of all, again, this wasn't raised. Secondly, no, because but for that incorrect entry, he would not have gone to hospice. The other defendants acknowledged their error in failing to confirm the diagnosis, but that's for a jury to apportion fault among the physicians, essentially.
So there could be fault, but maybe not as much because other health professionals could have done something else at the hospice.
Yes, everyone.
There can be more than one proximate cause.
Right, it all started with this single entry by Dr. Winograd in this case. Just give me, see, I'm almost out of time. The plaintiff raised questions of fact.
I guess my question is that, I'm just listening to the responses here. Do we even get to the standard of care? Because normally in some med-mal cases, we don't have this kind of unique situation where you have patient says, I said that, and the doctor says, I heard this, right? I mean, do we even get to the standard of care? But we still have a fact issue before we...
You have an issue with the standard of care because their expert, the defense expert, Dr. Sama, says it's appropriate to act on the patient's information and give him a referral to hospice. Our expert at page 541 of the record says it was a departure from the good and accepted medical practice to diagnose Mr. Candelario with stage 4 pancreatic cancer without proper testing and workup. And I see my time's up, but I'd like to point out that these defendants can't have it both ways. They can rely on what the plaintiff told them. Well, but if that's the case, then why did they order the diagnostic testing? How do you order a workup, a CAT scan, to check his pancreas and everything, if in fact you're now saying we were entitled to rely on the plaintiff? And I'd point out, you can't go to an emergency department and get medication for flu treatment without a diagnosis and workup, and yet they're asking this court to accept as a matter of law that a physician can take a patient at their word and give them a referral to hospice care. Thank you.
Thank you.
Respectfully, what is disturbing in this case is that the premise is that in a busy emergency department, a patient comes in saying they have 10 out of 10 abdominal pain, they have a history of cancer from 2 years ago, they've been treated with chemotherapy, they want hospice care, and now the defendants are supposed to...
Are you saying that it was a plaintiff who was asking for hospice care?
Yes, the plaintiff and his relatives. It's documented in the chart.
I think the relatives, I did see that.
I do believe there were
The
reference...
plaintiff asked for hospice care?
I believe there was reference in the chart for both the plaintiff and the relatives, but I do want to go off, I only have 2 minutes. I want to respond to two things that the plaintiff said. First of all, they were faulting St. Barnabas for giving him a referral to hospice. St. Barnabas did not give him a referral. The emergency department called a consult. That consult was Dr. David Anand, Hospice of New York. Dr. David Anand accepted him to hospice care based on his consultation. Secondly, this is not but-for causation. What happened with Dr. Anand on July 22nd is an intervening cause that could not be anticipated, that a subsequent physician who's treating the patient would learn that the diagnosis was questioned, it had not been confirmed, and that he would not then act on that.
When did the patient went into hospice care? July 11th, right?
He was referred to a consult on July 11th. I believe he went on July 12th. This happened July 22nd.
Why wouldn't there be arguably causation, even under your theory, between 12th and the 22nd?
If that was my fallback argument, even if there is causation, it's only for that 10 days.
Why shouldn't the jury decide that as opposed to us, assuming that you didn't raise it for the first time in reply?
No, and the reason it was raised, first of all, proximate cause was argued in the underlying brief, and the reason that this issue was explored the way it was in the reply brief was because the plaintiff obviously mistook the actions of Dr. Anand in Hospice of New York for the actions of St. Barnabas, and they were describing the liability of the hospital based upon Dr. Anand's acts and Hospice of New York, and that clarification needed to be made, and therefore the legal argument was expanded.
Okay, thank you. Thank you both. We'll certainly look at this carefully, like we do with everything. The next case for argument is Matthew versus DeRose.
Good afternoon. Susan Etra from the law firm of Yoeli Gottlieb and Etra on behalf of Appellant Montefiore Medical Center. This appeal is not designed to get Montefiore dismissed from the case, but rather to dismiss the two remaining direct claims against the hospital. The first is that the hospital caused a delay in this patient's surgery between November and December 2016. This should be dismissed because in the opposition to the motion to re-argue, Plaintiff confirmed through their counsel and their expert that the delay in the performing the surgery had nothing to do with the injury in this case, which was a cardiac arrest that was sustained by the patient.
I want to just interrupt, because I thought
Sure.
there were 3 departures that were subject to this appeal that we were addressing, and you just said, are you saying there are only 2 departures that are being appealed?
I'm talking about the direct claims against Montefiore. I don't represent Dr. DeRose. He's not part of this appeal.
But why are you saying there's only 2 direct claims against Montefiore?
So I said we're not asking for a complete dismissal. Montefiore Medical Center is the employer of Dr. DeRose.
You asked
We
for
will be in the,
dismissal of the direct claims against Montefiore.
yes, exactly. There are only
And you're
2
saying there's
direct
only
claims.
2 direct claims against Montefiore?
Yes.
Okay, go ahead.
The first direct claim is that the delay in surgery caused his injury. That claim was removed by the plaintiffs on re-argument, and it's in the papers in the court's decision. In the record at page 12203-04, plaintiffs affirmed that the delay in surgery had nothing to do with the cardiac arrest sustained. It was a perioperative event they're claiming resulted due to the surgeon, Dr. DeRose's failure to properly de-air the heart at the conclusion of the surgery. The plaintiffs are claiming that the cardiac arrest sustained postoperatively due to the air embolism that developed resulted in a 12-minute of asystole where there's no circulation, where the patient sustained brain damage, and as a result of that and his inability to be resuscitated, he was placed on the last-ditch effort to save his life, which is called ECMO, which is a machine that basically is outside the body and pulses blood and oxygen to the lungs and through the extremities. It's the patient his heart and lung is not functioning, and he had to remain on ECMO for a long period of time.
I'm still confused about what claims we're addressing here. One claim is the delay in surgery.
Right.
One claim is based on the installation of the DPC, how timely it was done. But I thought a third claim was that it was not done in the optimal location, that it had been placed in a different place. So don't we have to analyze all 3 of those claims?
Right, so the first claim is that the delay caused the injury. I was just going to get to the second. The only direct claim after that, I'm talking about causation, is that the improper placement of the perfusion catheter when the patient was placed on ECMO was
But
not...
isn't there a third claim based on the delay in installing the DPC generally?
Well, no,
You're putting those 2 together.
It's the placement of the catheter. There are 2 parts to it. They're claiming it was improperly placed. You're correct. They're claiming it was placed in the wrong place, and they're claiming it should have been put in earlier.
So why isn't there an issue of fact with respect to the location installation of the DPC?
The plaintiff's expert testified that they should have put the catheter in the minute he was put on ECMO, and that they delayed 4 hours in doing so. There's absolutely, it's a conclusory statement that is not...
I'm sorry, let's separate those 2 out, because one is the timeliness of it, and you're making an argument that there's no causation, but a separate argument they're making is that it was placed in the wrong location. And they say if it had been placed in a different location, there would have been a different result. Why doesn't that opinion as to the location of what was placed create an issue of fact that should go forward?
Putting that catheter in a different location wouldn't have made any difference, and that was pointed out by the defendant's expert, Dr. Faries.
I understand that your expert says that, but plaintiff's expert says something different and offers an opinion directly going to that issue that it would have made a difference. If so, why doesn't that create an issue of fact?
Because what their expert did was make the conclusory statement without any clinical basis and not based on the clinical evidence. Because the catheter that was placed in 4 hours after the patient was placed on ECMO resulted in increased perfusion to the extremity, no acute injury to the extremity, and there was never any sign of tissue ischemia in this patient over the next 4 days. There's absolutely no connection with the placement of that catheter subsequent to the starting of ECMO
What
to his
about
injuries.
the opinion of the plaintiff that it would have allowed for greater blood flow which would have prevented the ischemia from happening.
Because it also has no underlying basis in medical fact. This patient had 2 huge cannulas inserted by way of the ECMO device. One was in the femoral artery, one was in the femoral vein. There's a perfusionist sitting next to the patient, pulsing blood throughout his body. The problem with ECMO is it kept this patient, thank God it kept him alive because of their heroic efforts. Unfortunately, ECMO, the body's response to ECMO is that the blood is taken from the extremities and they push it to the 3 major areas of the body that need the blood. That's the heart, the lungs, and the brain. It doesn't matter if you put in, our experts said it would have made no difference you put in another catheter later on. What you do when a patient's on ECMO is you watch him and you check his pulses and you check whether the arteries are patent. And our experts showed how from the moment that ECMO machine was placed until the ischemia was noted, his pulses were documented, his arteries were patent. There is no evidence of any departures on the part of the staff, whether inserting this catheter in this place or not. There's just no evidence. It's completely speculative to argue. And the proof is in the pudding. If you look at the expert's opinion on this issue, he does not say at any point that the placement of that catheter in the wrong place causes the injuries, because he would be foolish to do so. He's claiming because he needed to be on ECMO because on cardiac arrest, and acknowledging that when you go on ECMO, you're going to have increased risk of loss of perfusion to the extremities. And in addition, the need for being on blood pressure medications for 2 weeks, blood pressure medications in and of themselves for an extended period of time in a patient who has gone through what this patient has gone through, in and of themselves can cause loss of perfusion to the extremities because the smaller blood vessels are constricted, and they too, like the ECMO machine, send the blood back to the major organ.
Okay.
So our point is that there is no credible issue of fact. It's just a conclusory statement that wasn't based on the clinical picture, and therefore we believe they have not made out a case on that issue.
Okay, let's hear from the plaintiff, and you'll have a few minutes on rebuttal. Thank you, Ms. Etcher.
Good afternoon. I'm Stuart
Good afternoon.
Diamond. I'm here for the plaintiff.
Sir, can you address, with respect to whether or not the DPC was located in the proper place? Your adversary says that essentially your expert's opinion is not based on the evidence, it's not based on scientific evidence, and also it's speculative.
So it's not speculative and it's not conclusory. There's actually 3 elements of it, which wasn't addressed. We argued also that it was the wrong size catheter, that it was placed in the wrong place, and that wasn't conclusory. He explained the difference between antegrade and retrograde flow of blood, and that because the catheter was placed in the top of the foot rather than in the femoral artery, the blood was flowing against the flow of blood in the body. It's not conclusive.
But how does the ECMO then, but don't we need to look to see what actually occurred and that he was on this machine, essentially that was saving his life?
It may have saved his life, but that doesn't preclude the possibility that it caused all these other injuries that were entailed.
Your expert rejects that it was the ECMO that caused the risk of all the injuries to the extremities.
Absolutely, and I'm a little
What's the evidence he substantiated, he or she, the doctor substantiated to show that having it in a different location would have resulted in a different outcome in this case?
Because
other than the conclusion that it's so.
Other than
What's the evidence to substantiate it other than the conclusion that that is so?
it wasn't just the mere conclusion. He explained that because of the location of where it was placed, it worked against the flow of the blood within the body. Also because
Did he make any argument that that's generally accepted, that the location can affect the outcome?
Yes, that's exactly what he said in his affirmation. I'm a little bit at a loss because counsel started by saying they're not seeking to dismiss the case against the hospital, if I understood her correctly. That's not the basis of the motion. It's either motion. It's not the basis of the appeal. This is the first I've heard about it, and I don't know what counsel means about direct claims versus, I assume, indirect claims. These are all claims against the hospital. The hospital is vicariously liable for anything that was done by any of these doctors. They haven't argued otherwise. We cited the plaintiff's, Dr. DeRosa's testimony, Dr. Chow's testimony. They all work for the hospital. This is an artificial distinction. These are all claims against the hospital.
Have you withdrawn or changed your claims with respect to the timing of the surgery, or are you still?
No, absolutely
Okay,
not.
so let's then deal with that. So,
Yes.
so the defendant's expert says very specifically that the delay didn't cause an increase of what occurred.
Yes.
How does your expert respond with specificity to that argument?
It's not only our expert. That same defendant's expert said that congestive heart failure requires emergent surgery. He said that Mr. Matthew didn't have congestive heart failure, but that's directly contradicted by the record. Then their own three doctors, Dr. Poma did Dr. Taub did a preoperative medical assessment in which she said that this man needed immediate surgery and that he ran the risk of sudden death or heart attack or heart failure if he didn't have it. Dr. DeRose, the one who did the surgery, said that the surgery, the heart attack was not caused by an air embolism, but was caused by essentially by the delay, which caused the backup of blood into his lungs and made his surgery more difficult. And he himself raised that issue. And then the third doctor, Dr. Chow, who came on the scene afterward, attributed it to the fact that the blood clots weren't cleared, and so it's not true that we conceded that it was only because of an air embolism. And even if that were the case, Dr. DeRose, who would be responsible for that, was an employee of the hospital. These are all artificial distinctions. There is no direct claim against the hospital or indirect claim against the hospital. And they didn't make that distinction when they made the motion or made their appeal. This is something new that I've never heard before, and it's irrelevant, really, to the resolution of this appeal.
They're just saying they're not appealing the entire decision, just the decisions with respect to the direct claims against Montefiore.
I don't know
that's
what
all
they
she's
mean by
saying.
direct claims. They're all direct claims.
Well, derivative claims, vicarious, I don't need to discuss with you. They're different than
As a
direct.
practical matter, I don't see how that could have possibly affect the appeal, whether they're derivative, whether they're vicarious claims or whatever, if you want to call it a direct claim.
Counsel, we're focusing
Not
on the
entitled to
departures.
dismissal.
We're
of it.
focusing on the departures here. Those are the issues before us, so, you know.
Okay, so we are absolutely maintaining, based not only upon our own expert, but also on their own three doctors and their expert, who said that not only the heart attack, but the stroke, the renal failure, the amputation could have all resulted from the delay in.
Could have?
Well, our expert said that it did. I only use the word could have because I'm referring to their three doctors' testimony, and it varied. But our doctor specifically attributed to that delay. And there's no question that there's nothing in this record. It's a 622-page record. They point to one page, an entry by a physician's assistant, not a doctor, who said he would likely benefit from surgery. And somehow that is an indication that he was told that he shouldn't leave the hospital without having surgery. There's no other reference in the record to that. And based upon the preoperative medical assessment, where the doctor was cleared for surgery, and the discharge instructions, which said nothing about surgery, said nothing to him about the risk of not having surgery, had the wrong diagnoses, called it coronary artery disease when coronary artery disease had been specifically ruled out by a cardiac catheterization that he had on the first day of his admission.
Thank you. Counsel.
Thank you. Firstly, it's important to note, no matter how many catheters you put in a patient who's on ECMO, which would be contraindicated because you would increase risks for all kinds of problems, the blood flow when a patient is on ECMO is not going to be directed downward for a very long period of time because the patient's body's response when they're on ECMO is that all the blood and the oxygen within that blood is going to be directed from the extremities to the heart, the lungs, and the brain. And that is why this complication that has happened with this patient is known throughout the literature. His experts acknowledge it to be a known complication because doctors can't prevent against it. In this case, our expert meticulously demonstrated, Dr. Faries, the vascular surgeon, how his pulsars were checked. They did artery testing to show the blood flow. Counsel's argument that a different size catheter in a different place would have increased the blood flow or that was impeded is just not supported by the medical record. The documentation is there. It's in Dr. Farry's affidavit. Blood flow was fine in that extremity after the catheter was put in. His perfusion was better. That was December 14th. It wasn't until December 17th that there was a problem noted in the extremities, and it wasn't the right foot, it was the left hand. So this patient was monitored regularly. It wasn't until December 18th that there was first sign of ischemia, loss of tissue perfusion in the extremities, and that was in both the left and the right lower extremity. There was ischemia in both. To say that they're not withdrawing claims that the delay in the surgery caused these injuries.
Well, let's put that aside for a second, whether they're doing it or not. Did plaintiff's experts specifically respond to Dr. Grossi's opinion that the delay did not increase the risk of complications? Is there anything specific in the expert's response?
Absolutely none. The plaintiff's expert did not address anything that Dr. Grossi said. I want to make two distinctions, if I may. If you look at the court's decision and the plaintiff's papers, it is clear they state unequivocally that the delay in the doing surgery did not cause the air embolus, which resulted in the cardiac arrest. It's in the papers, it's in the record, okay? Number two, it's very clear that, I'm sorry, I just forgot the second part of your question.
It doesn't matter, you got a red light, so. Excuse me.
We have the record. We'll take a further look. Thank you both very much. Next case for argument is Peter Green versus NYU Langone.
Good afternoon, Your Honors, and may it please the Court. My name is David O'Brien. I'm from Giskin, Solitaroff, and Anderson for the plaintiff appellant, Ms. Peter Green. This is a case where a jury could easily conclude that Ms. Pitter, a black woman, was terminated from her employment for trumped-up reasons by supervisors who had a demonstrated history of racism towards black people. Specifically, Arceo, the supervisor of the outpatient laboratory, participated in the termination and subsequently said that black people, quote, don't like to work.
How many years later?
3 to 4 years later.
3 to 4 years later.
Yes.
What's the connection between that adverse employment action, which was based, as I understand it, on violations of HIPAA, which was later reversed? How do those two connect?
Well, one, I believe it's important to view this statement in the context of this years-long imposition of a racial double standard in the office, whereby black employees were required to do more work, were overly scrutinized, and were treated materially different by Mr. Arceo and Mr. Vargas over a course of years. And this is a statement that speaks to Mr. Arceo's attitudes and beliefs regarding black people in the workplace. And I believe that a reasonable jury could infer that he didn't form this opinion just recently before making this statement, especially considering the context that I just discussed. And regarding Mr. Vargas, who referred to black people as you people and also imposed that same racial double standard, he terminated Ms. Pitter for keeping health records where he instructed her to keep them. Both Arceo and Vargas, as I discussed, had a history of this double standard regarding phlebotomists under their management, but also the clinical workers and the intermediary supervisors. But the IAS court failed to read the record in the light most favorable to the non-movement and to provide the non-movement with the benefit of all the reasonable inferences. Instead, the court looked at the record in a very strange way, almost going out of its way to grant summary judgment. The court focused on trumped-up issues with plaintiff's performance that had nothing to do with the termination, and then ignored the fact that the supervisors were demonstrably racist. The termination was obviously not legitimate because NYU reversed it, and Vargas, who spearheaded the termination, was caught shortly after her reinstatement.
Were other black employees, were they terminated for HIPAA violations, keeping confidential medical records in their personal lockers?
I don't believe the answer to that question, Your Honor, is in the record. I don't know if there's a record, if there's record that...
Isn't that important to know?
It would be important if there was a record that they had kept that they had committed the same alleged violation, and especially if they were instructed to do so. However, we do have in the record.
The people that you interviewed, did any of them say that we were terminated for this reason as well?
We didn't find anyone who was terminated for this exact reason, but the union found people who committed the same offense who did not share the same protected characteristic, who were not terminated in the similar circumstances.
Which was the basis for the reinstatement.
Correct, when NYU found out that its supervisors had fired her when similarly situated people were not fired for that same act. And I believe that supports the reasonable inference that the termination was discriminatory.
But was there a HIPAA violation or not? Irrespective if other people were doing it, was there a HIPAA violation keeping personal records in a locker?
Well, in fact, the record supports that they were not in the locker, they were in the cabinet, which was consistent with NYU's policy and not a HIPAA violation. Ms. Pitter made this point to Mr. Vargas when he was terminating her. He said, "I don't want to talk about it." And his leg was shaking, and he continued with the termination. She said, "You told me to do this." I kept him in the cabinet. With respect to the hostile work environment, a rational jury could have concluded that Arceo and Vargas treated Ms. Pitter and other Black employees differently from the non-Black employees and subjected them to inferior terms and conditions of their employment every day. For example, in who was permitted to take bathroom breaks and when, whose requests to take vacation time on certain days were granted, in requiring Black phlebotomists to process more patients per shift than other phlebotomists, in tolerating mistakes by Hispanic and Filipino employees while harshly criticizing and sometimes imposing discipline on Black employees.
Are those just, and I don't wish to minimize it, are those just petty slights and inconveniences, or is it something more?
Well, respectfully, Your Honor, and I'm seeing the red light, these materially affected the terms and conditions of the employment. That created an in-group and an out-group. It created a class of people who had to work harder and do more and face more scrutiny than other people. And I also believe that under the New York City human rights law, it's the defendant's, the employer's burden to show that the disparate treatment raised to the level of beyond the trivial, and the IAS court failed to independently examine the NYC HRL claim. I'm seeing the red light.
Yes, no, that's okay. We're happy to have you finish that one answer. We'll hear from the other side, and you'll have a few minutes to respond.
May it please the court, my name is Richard Steer. With me is my partner, Justin Chu, and we're the attorneys for the respondent, NYU Langone. Let me start with something that was just mentioned, and that is the idea that the individuals in the lab, based on their race, were treated with inferior terms and conditions of employment. It's certainly clear that when those specific claims were looked into, the testimony came out, like, for example, from Ms. Alberger, whose testimony is in the record. They say, well, African Americans, they were disciplined worse than Hispanics, except Ms. Alberger said, I've never seen anything about the records of any Hispanic, or I don't know what their disciplinary records were or how they were disciplined. So we have these conclusory allegations that basically that Vargas and Arceo are racists. And the fact of the matter is that with regard to the termination, we have the fact that the respondent found that there was a HIPAA violation. It was reported by Mr. Vargas to his boss, who it was admitted did not discriminate against appellant. And then what happens is it is also undisputed in this record that a HIPAA violation is a compliance issue, and they made the decision that termination was warranted. And I would just also, they say, well, the decision was wrong. You shouldn't have done it. But I would point to a case that I believe Judge Kapnick was on the panel in a case called Hamburg versus NYU 166 AD 3rd 66, it's a 2017 case that held that a legitimate reason for termination, even if it's wrong, is still a legitimate reason. And while I don't agree it was wrong, I think at most that's what we're dealing here. Also, this court in the Melman case, the very well-known Melman case, held that in an employment case, courts should not sit as a super personnel department to evaluate employers' conduct. With regard to the issue of the alleged remark about you people, which alleged to be discriminatory, all the cases cited by the appellant say you have to look at the context. Facially, the words you people are not discriminatory. You have to look at the context. There is no context in this record that shows anything discriminatory. This is not like a case where someone says, get those people off my couch that was talked about. And so what we have here is a situation where we have an employee whose performance was considered improper, both before—
Let me stop you there for a second. Were non-black employees, were they treated differently with respect to this issue, the storing of records?
Your Honor, there are two answers to that. First, we don't know because I don't believe this record actually has evidence in it as to what the actual race, national origin, the like of those people were that were not terminated. But I can tell you is, according to the record, that once it was found by NYU that Ms. Pitter was treated differently, even though they didn't know at the time of her termination she was being treated differently, she was reinstated voluntarily by NYU. And the second thing that I think is important with regard to that, in terms of the treatment, is that combined with the lack of knowledge and the fact in the record that we don't know the race, national origin of the people who were kept, it's not this appellant's burden, respondent's burden to put that in the record. The law is absolutely clear that no defendant has to prove freedom from discriminatory motive. It is the respondent's duty to prove pretext. We did not have to prove that those comments, that the context of those comments were done in a manner that would be non-discriminatory. It is the burden in a disparate treatment employment discrimination case, it is the burden on the plaintiff to prove the discrimination. One last thing, Your Honor, I would just say that this case really falls into line.
What about the deposition testimony that the plaintiff annexed from Ms. Goffey, who filed her own, the deposition testimony that the plaintiff annexed from Ms. Goffey, who also started her own lawsuit? Didn't that bolster, or not bolster, but add to the testimony, support the testimony of the plaintiff in this case as to some of the problems that the black employees were experiencing as opposed to some of the other employees?
Your Honor, I would respectfully submit that first of all, this is not the Goff case.
I understand that.
She, for example, found that supervisors like that were Hispanic, that she claims discriminated against her. Ms. Pitter said they never discriminated against me. She says comments were made. In 30 years, Ms. Pitter only heard one allegedly discriminatory comment. When you look at the actual evidence of the supposed differing treatment, supposedly they stood outside Ms. Pitter's door, the appellant's door, when she was looking to draw blood, and she had the door closed. She couldn't see what they were doing with others, but when she opened the door, they got a new patient and gave it to her. So Ms. Goff, while she makes all kinds of conclusory allegations, and she was a clerk, her circumstances were very different than Ms. Pitter, who stayed until her termination after, her retirement after 30 years. Ms. Goff had problems throughout, but this case is the case of an employee who had bad performance before Mr. Vargas became the lab manager and after. It was well documented, and this court has held that well-documented poor performance is a legitimate reason. I would just cite to the case that I think Judge Kern was on, Miller versus News America, 162 AD 3rd 422. that held longstanding documented dissatisfaction with plaintiff's performance and work quality is a legitimate non-discriminatory reason, and in that case, this court affirmed summary judgment. We respectfully submit the summary judgment should be affirmed here. Thank you.
Thank you.
I just want to address briefly some arguments that my opponent just made. One, he says that Ms. Alberga testified that she never saw the records of the other people who were given unfair discipline. However, she testified that she herself was unfairly disciplined. She knows her own record.
But isn't it important for you to show how non-black employees were treated with respect to that issue, with respect to violation of HIPAA and confidential records?
I do think that, well...
It would make a stronger case, right?
I think
Hispanic employees were not affected adversely, and black employees, or a black employee was your client. Wouldn't that be a stronger case, and don't you have to show that?
Well, I believe that, yes, of course, regarding the termination claim,
right,
not the hostile work
I'm talking
environment.
about the adverse employment action.
Well, the testimony is clear that they had this persistent racial double standard, and I think that that can be used to infer that the termination, which I want to address why we know that it was not legitimate, was motivated by discriminatory intent, by racial animus. One, there was no mistake. Vargas knew what happened and he terminated her the day that he confronted her about complaining about his harassment of her. And then shortly after she was reinstated, he was caught egregiously hiding a urine sample that Ms. Pitter was responsible for, pretending he didn't know where it was, and then was caught red-handed when it was found in his bag by Ms. Goff. So I think that given that context, it's clear that the termination was bogus, and a reasonable jury could determine that it was motivated by racial bias. I also want to, discuss the
Discuss it quickly.
the argument about that she only heard one comment. First of all, this was an office where Vargas and Arceo and many employees spoke Spanish, so it's not surprising that she didn't hear or understand much of what was communicated between them. And also, my opponent has minimized what the context is. He focused on the words before and after the statement and not the overall context of how he treated black people in the workplace. Thank you.
Thank you. Thank you both. Next case for argument is People versus Dennis Martinez. Good afternoon.
Good afternoon, Your Honors. My name is Brian First from the Center for Appellate Litigation, and I represent Dennis Martinez. This case is about junk science in our courts and defense counsel's duty to guard against it. Defense counsel here had an unequivocal duty to challenge Park's bloodstain pattern analysis because, one, it was completely false, and two,
What difference did that make to the case, to the outcome of the case, and to his evidence of being found guilty?
what difference does it make that
Well, how did that impact the finding that he was or was not guilty in this case, the blood splatter?
Oh, because this, if true, it completely precluded the only defense theory in the case, which was justification. The defense theory was that Mr. Martinez had stabbed the decedent in his bedroom as the decedent attacked him, and then the violence ended. The point of Park's testimony was that following the altercation in the bedroom, Mr. Martinez stabbed the decedent as he lay on the ground bleeding out in the hallway. So even if the jury fully credited everything Mr. Martinez said happened in the bedroom, which was defense counsel's strategy here, if they credited Park's testimony, that was the whole ballgame.
But why is that? I don't understand that, because wasn't there other medical testimony that there was one or at least two downward stabbings, which suggests that the decedent was on the ground or close to the ground? Wouldn't that be a basis to negate justification? Your guy has the knife, and the decedent is in a vulnerable position, and they're downward stabbings.
No, downward was just the angle of the stab wounds into the body.
So what does that mean? But what does that suggest?
No, it doesn't suggest that at all, Your Honor. If the decedent was charging my client, as he says he was, and he's stabbing like this, as long as any stab wound to the torso could be a downward stab wound. We don't have any evidence about the actual degree of the wound, and even if you think about him being above the wound and stabbing straight down, that would still go straight in. That doesn't just because there's a downward stab wound doesn't mean that he was above him in any way. As you know, Mr. Martinez, so long as his shoulder wasn't above.
Who had the weapon at this point?
At the point of when Mr. Martinez had the weapon at that point. Right, so that goes to the issue of justification, Your Honor, but we're talking about, listen, Mr. Martinez, he's in his 50s. He hasn't committed a felony in 27 years. He's sleeping soundly in his bed at 4:30 in the morning when a man who's notoriously violent when he's drinking, belligerently drunk, bursts into his bedroom and instigates a fight where Mr. Martinez gets a wound to his leg. There's knives around the room, right? There's knives all over the place. If this man just tried to kill him with a knife and he continues to attack him, Mr. Martinez's life is very much still in danger. That didn't end the situation just because Mr. Martinez had the knife. He was not dealing with a rational actor, but an out-of-control, blacked-out, drunk person. So just to Park's testimony, just so we're all on the same page about Park's testimony of why it was false. Park said that the 2 bloodstains on the hallway wall were about 6 to 8 inches off the ground. They were about 1 inch wide each. That the shape of them showed that they hit the wall moving at a downward right to left motion. Right, that was the that's called the directionality. That was the trajectory of the bloodstains. So that's fine. That's basic bloodstain pattern analysis. Anybody with a textbook could figure that out. What he did with that information was the junk science. He said because those blood droplets were moving downward and right to left, whatever caused them, he said actually what did cause them was a downward right to left stabbing motion, which he demonstrated on the stand, just like this, as the judge narrated, above his right arm, right shoulder, and down to his left thigh. So that's complete and utter junk science. There's no truth to that whatsoever, literally impossible to determine, and that's what our expert affidavit in the 440 court showed.
Was there a strategic reason maybe that counsel had not to question?
There's not one in the record, Your Honor. In fact, the affidavit that counsel submitted in his conversations with motion counsel suggested that he just completely missed this. The people hypothesized that maybe he was choosing not to challenge it in order not to distract from his cross-examination strategy, but that's not what counsel said. And under Strickland, we don't deal in hypothetical strategies. We ask, what was counsel's actual decision-making? That strategy does not make sense for a variety of reasons, but even so, at the very least, that just created an issue of fact that should have been resolved at a hearing, but the court summarily denied the petition. So, but the reason that doesn't make sense is because the best time to challenge Park's testimony was during direct examination. He didn't have to change his cross-examination at all because Park was supremely unqualified to give this testimony, and his methodology wasn't just unreliable, which expert testimony must be, it was just non-existent.
Was he even ever qualified as an expert?
He wasn't qualified as an expert.
He's a detective.
He was a detective. But make no mistake, bloodstain pattern analysis is expert testimony, and to reconstruct the events that caused a specific bloodstain is extraordinarily complex and well beyond the knowledge of a juror, and is, even if the witness is unqualified, it's still expert testimony. So, I guess as to prejudice, this was, no matter how the people characterized this case, it was extremely close. The jury deliberated for 3 days. They were deadlocked at one point. When they were deadlocked, it was defense counsel who requested the Allen charge, clearly indicating that he thought he was going to win. And then ultimately they acquit on the top count. And I see I'm out of time, so I'll reserve the rest of my time for rebuttal.
Great.
Thank you.
Thank you very much.
Good afternoon, and may it please the court. Paul Anderson for the people. To go right back to Strickland, the Supreme Court says you can look at prejudice first to evaluate a claim of ineffectiveness here. And so to look back at the record in its entirety, the decedent suffered 7 wounds with the knife, 4 stab wounds in the chest. 1 was from decedent's right to left upwards, 2 were decedent's left to right downwards, and 1 they couldn't.
What do the downward stab wounds suggest?
It suggests that the stab wounds came from above the taller decedent.
And who gave this testimony? The medical examiner?
Dr. Priel gave the medical testimony about
Was
the
there any
directionality.
objection to this testimony?
No, Your Honor, no objection, and that's what the jury actually wanted to see when this came back into
So
deliberation.
then how does that connect? Because to your adversary's point with respect to the blood pattern analysis, et cetera.
Well, I think it's a much stronger indication of what occurred here, especially when there is additional testimony that what in this splatter at issue occurred in the hallway, a very narrow hallway that the jury had access to the pictures, Your Honors did. The jury also heard that there were 2 police officers there, 2 EMT technicians, the defendant, the decedent, all in that narrow hallway, trying to, quote, patch up, it was like patching up a hose in terms of stopping the bleeding, and that they candidly admitted, trying to move the decedent, that they had to drag him over there. So there was plenty of alternative reasons for how that splatter happened, and in fact, that's essentially what their expert testimony or their expert affidavit says here. And it's really just an issue of would the counsel have wanted to drag this into a battle of the experts rather than this defendant with such severe credibility issues that the jury had to sit and watch over the course of like a full day of him saying hours that someone else did this, to then say, well, I want to.
But that may be. But still, the issue is nullification. Is whether or not there was justification, right? That's a separate issue. I would suggest to you.
Yeah, well, yes, Your Honor, but it's still the evidence of who attacked who first came from defendant's interrogation here. And even if you just look at how my opponent qualifies that interrogation on page 8 of the brief, they wrestled for the knife, and his client was cut. So it's not so much that came at him with the knife and stabbed him and then disarmed him. It was a wrestle for the knife. He got the knife back.
From an intoxicated person.
From the intoxicated person, 0.25 blood alcohol level, struggling to get up, as defense counsel pointed out, like him trying to claw up on the door. He gets the knife and then stabs him at least 4 times in the chest. We can excuse the cuts, the other remaining cuts, but still, stabs him 4 times in the chest. And all of that, I mean, as counsel was trying to argue, that occurred in the bedroom and trying to rehabilitate his client's credibility to the jury of like, yes, he may have lied for 6 hours, but at least all of his testimony or his interrogation of what happened in the bedroom, let's credit that and and see if we can get a better result here. And even taking a step back and just describing how this crime occurs, it matches up more with an extreme emotional disturbance defense. And so, in that defendant is sleeping in his bed, a triggering event occurs, and overcome with emotion, he takes the knife and stabs him. And while that wasn't the defense pursued by counsel, that's the result we have here. And I think that's really what the jury struggled with, even without the absence of that instruction of what was the intent of Mr. Martinez here. Not whether he was justified. Did he have the intent to kill, or did he have the intent to seriously harm? And so asking for the readback of the testimony of the interviewing detective and asking for the medical examiner's testimony, that informs that analysis here. And so taking that all together, this speculation by a lay witness, so it didn't even have the veneer of, oh, based on your massive training in blood splatter technology, you see this. It came out, yes, and the prosecutor tried to use it. Counsel still made objections, blunted it.
And were they granted those objections?
Yes, and a curative, in that this was just speculation. You can't consider that during closing arguments. But at the end of the day, as the 440 court found, this is a weak justification case. And so whether counsel, who admitted to having counsel in his affidavit said he had experience challenging blood pattern analysis, made that decision of, I'm not going to do it here, or just I didn't think it would come up that much and wanted to focus on the actual tangible aspects that he could focus on here. That is reasonable here, and that is objectively reasonable. And so we ask that you affirm, Your Honors, if there are no questions. Thank you.
Thank you.
Thank you. Just briefly, Your Honors. So first, everything that he just said about counsel's thought process is not in the record. So none of that could support, you can't uphold this as a strategic decision if counsel didn't say any of that. There's no place for hypothetical strategies here in Strickland, under Strickland. But as to the wounds, again, this idea that, first of all, during summation, the trial prosecutor never said, oh, Priel's testimony, the downward stab wound proved that he was standing above him when he stabbed the decedent. She used Park's testimony. She said that Park's testimony.
And was there an objection to that testimony?
There was not there was an objection to 2 different instances. She used it several times. The objection was to the prosecution's guess that as to which wound was the final stab wound. It didn't have to do with Park's testimony. And there was one when she said when the decedent was crawling away, she was painting a gruesome scene of the decedent crawling away on the ground. That's when the defense counsel objected. It wasn't because she used Park's testimony. When she said Park's testimony is important because it tells you there's no self-defense and then explained why, there was no objection whatsoever. So, and Your Honors, I'd just like you to think about a downward stab wound. If somebody's charging at you and he's leaned over, he's charging at him, he has 4 stab wounds to his torso, anywhere from his...
All this is put before the jury, right? I mean, in terms of the downward action, where the stab wounds are, these were all played out in front of the jury, right? I mean, what you're telling to us, and you're asking us to now accept that the jury got it wrong?
No, I'm telling you that the jury relied on Park's testimony, and that's wrong. That's the problem here. My adversary here is trying to argue that...
That's what Justice Singh said. You know, you had to raise the objections and actually challenge the testimony, and I'm not hearing that was actually made, right?
Say that again, Your Honor?
That's what Justice Singh was mentioning about, was there an objection to the certain testimony, and you were specifically highlighting what Park's testimony was being drawn out.
Yeah, there wasn't an objection. If there was an objection to Park's testimony, then it would have been precluded, but there was never an objection, so the jury had it before them. Okay. Park's testimony was in with no objection whatsoever.
Got it.
Anyway, if just the last thing I would say about that downward, the stabbing motion, I was just saying that it's unlikely that the jury relied upon it because it's just nonsensical to say that a downward stab wound into a body means somebody was standing over them. If you just think about that in terms of positioning and where the body would have been, if he goes like that, that's a downward stab wound. So I don't see how that could have been what swayed the jury. Thank you, Your Honors.
Thank you. The next case is Hockaday versus Hessel. Justice Ong is recused from that case.
Good afternoon, Your Honors. May it please the Court, Otto Chang from Milburn Macris, plus status and on behalf of the defendants, appellants, DeCarlo Distributors, and Richard Hessel. Your Honors, while we will primarily rely on the arguments made in our briefs, the only thing I'd like to address on this oral argument is what is admittedly kind of the elephant in the room on the record on appeal, the DeCarlo Company incident report, containing the statements of Richard Hessel that the lower court and the plaintiff tried to portray as an admission of liability in this motor vehicle case. However, Your Honors, it is not an admission of liability. While Mr. Hessel may have commented on additional steps that could have been taken, that is not dispositive of what the initial cause of the accident may have been, and more particularly, that it does not do away with the remaining questions of fact concerning comparative fault, at the very least, particularly in light of not only Mr. Hessel's affidavit, but the police accident report, which also cited the plaintiff with her own pedestrian error, with the dash camera video that is a part of the record showing Mr. Hessel and DeCarlo's tractor trailer turning at no more than 7 miles an hour.
What are you precisely looking for? Are you saying that we should reinstate comparative fault, or is your primary argument that there should be a dismissal here?
Well, the primary argument, Your Honor, is that the decision as a whole should be overturned.
So didn't Hessel admit not seeing plaintiff?
Well,
and isn't that a violation of 1146 of the VTO?
Not necessarily, Your Honor, because there is a question.
Let me put it another way. Does it raise an issue of fact?
It does raise an issue of fact on liability itself, Your Honor, because...
So therefore, we shouldn't be granting you summary judgment.
Well,
you agree?
No, well, I was not the movant in the lower court for summary judgment, Your Honor.
Right, but that's the question. Is this really just about whether the comparative fault should be reinstated as opposed to... I mean, you're sort of acknowledging that there's some liability on your client's part, or based on the facts presented, there's an issue of fact as to whether there's liability on your client's part. No. So why you should focus your argument on why the comparative fault should be reinstated also.
Well,
and why should it be?
Right. Well, what I would say, Your Honor, is...
What's the evidence in the record to support your argument as to comparative?
Right. Well, to address comparative fault first, Your Honor, then, in that case, we respectfully submit that at the very least, there is plenty of evidence in the record to support comparative fault. Just by the mere fact that you have a slowly turning tractor trailer in plain view at no more than 7 miles an hour in broad daylight, The police report cites the plaintiff with her own pedestrian error.
But isn't the issue there whether or not, where the plaintiff was located? Was she in the crosswalk? Was she out of the crosswalk? Isn't that really the question?
That is another question of fact.
And also, who had the light? Because it seemed there was some different testimony as whether or not you had the light or whether the plaintiff had the light. And I thought there was some conflicting testimony as to that also.
Yes, I mean, overall, there's a lot of conflicting facts between the police report, between,
The police report also included witness statements, and the witnesses never stayed around.
Exactly, exactly. And that's also why the motion, respectfully, the plaintiff's motion was premature, because the defendants didn't even have an opportunity to investigate those avenues. So at the very least, there are these countless questions as to comparative fault. I would respectfully submit that liability is also an issue.
Why?
Because, well, Your Honor, if we're going back to the...
Based on the admission of your client that he didn't see the plaintiff, is a pedestrian crossing is in the crosswalk or maybe not in the crosswalk?
Making a left turn.
And he runs into her. How can there be any issues?
If I may, Your Honor, I wouldn't classify it as an admission because there's a question of fact as to whether he had a reasonable opportunity to have seen the plaintiff, who, by the way, was also
She's running across the street. Is she darting like a kid? Or is she on a mechanized vehicle moving slowly across a roadway given her condition?
A mechanized vehicle that arguably placed her at a lower elevation, possibly outside of Mr. Hessel's view, and according to his affidavit, he did take at least those precautions. Now, while he did say in the company incident report, these are additional steps that I could have taken,
Right.
double checking, slowing down a bit. Again, he was already going.
Well, look,
at a
he
slow
didn't
speed.
see her, and he said he only, and he was moving slowly, he said, but he only stopped because he saw people like gesturing to him, like, stop, stop. So that's why he stopped, right?
But again,
So-
and I see I have the red light, if I may just
finish your...
complete my point, thank you. But again, at the very least, between the affidavit, between the incident report, between the police report, between the photographs and the dash camera video, those raise question of fact. What I liken it to, if the court will indulge me just for a moment, is if I'm driving down a road.
30 seconds.
If I'm driving down a road, if an oncoming vehicle crosses a double yellow into my lane, sure, maybe I could have taken additional steps by swerving into the shoulder to the side, but that doesn't mean that the initial cause wasn't still
But that's
the
not this fact pattern.
Okay.
That's just not this fact pattern.
Why don't you have a seat, and we'll hear from your adversary, and you'll have a minute to respond.
Thank you, Your Honors.
You want me to read from this? May it please the court, Michael Zhu, appellate counsel of the Parker Wakeman, attorneys of record for the
So how
plaintiff.
can there not be at least an issue of fact as to comparative fault on the part of your client in this case?
Well, I think after 2018, after Rodriguez, the plaintiff doesn't have to establish her freedom from fault.
I understand.
But the court made a determination as to that, so we have to address it.
Okay, so very easy. There are two issues, whether she had the light and whether she was in the crosswalk. Her affidavit states that before the accident happens, she's at the corner, she waits for the light to turn. As she's traveling across, and again, she's in a mechanized vehicle, as she's traveling across, she states in her affidavit that the light turns red, but it's changing and it's flashing.
But counsel, let's focus on the crosswalk first, because
Okay.
there does appear to be contradictory evidence in the record as to whether she was or was not in the crosswalk. Just that alone, isn't that sufficient to raise an issue of fact as to whether there's any comparative fault based on the contradictory evidence about whether or not she was in the crosswalk?
There isn't. Go to page 41. It's a photograph of the plaintiff laying on the ground.
But what about the police accident report, where I know you're saying it's hearsay, but it can at least be used on a summary judgment motion. Multiple witnesses states she was crossing against the green light and was not in the crosswalk. Upon police department arrival, pedestrian was found in the middle of the intersection, not on a crosswalk.
Because those statements are incredible as a matter of law. If you look at page 41 of the record, there's a plaintiff laying on the ground with her body in the crosswalk. The testimony is that she is run over by this truck. So her body doesn't move after it's run over. And if you look at page 41, her body is in the crosswalk. So the unidentified statements, the statements from these unidentified witnesses is incredible. It doesn't make any sense. I would concede the point if I didn't have this photo with the plaintiff laying on the ground in the crosswalk. So I don't understand how that turns into an issue of fact when this court states in Leo versus St. Michael's over 17 years ago, where you have a testimony from a plaintiff who says that it was raining at the time, and weather records show that it wasn't. Testimony that's contrary to physical and direct evidence is incredible. You can't accept that. Even though it raises an issue of credibility, if you have a photograph of a plaintiff lying in a crosswalk, then
Partially,
yeah.
She's partially out of the crosswalk.
Which
supports the statements in the police report that many people saw her outside the crosswalk. That supports it as equally as it refutes it, because she's not completely in the crosswalk. So I don't know how you get from that to incredible.
but we don't know who they are, first of all. And secondly,
But it's also consistent with the driver's testimony that she was not in the crosswalk.
the driver doesn't say anything about where she was because he never sees
saw her.
So the driver either in the police report or as an incident report never puts the plaintiff outside of the crosswalk because he doesn't see where she is. And the defense that, oh, she's in a mechanized wheelchair, so then children and short people are not protected when they're crossing the street within the crosswalk just because they're short and he's in a tractor
We're not going to hold
trailer?
that, don't worry.
I'm sorry?
We're not going to hold that,
Okay,
don't worry.
good, because I was getting worried there. Look, I mean, what it boils down to is you have an affidavit from the plaintiff putting herself in the crosswalk. You have,
But the picture is not quite as clear as you're making it. If she were fully in the crosswalk and the truck driver had done what he did, I think you have a very strong argument then. But that's not the case here, or at least I can't say that.
but you have no contrary evidence to say, hey, I
That's
saw.
not correct.
If I had an affidavit,
That's not correct. You have evidence in the police report which talks about what other witnesses said. This is a motion for summary judgment. Those hearsay statements can come in for just this limited purpose. Obviously, after discovery, all that, then it's a different story. But that's where we're at now, at this juncture.
that makes it really difficult because I can't defend that. If I have a person, I have a police report that says witnesses say this, but we don't know who they are, how am I ever able to establish a prima facie case to begin with then? What I'm saying is...
You got a liability finding, so you don't have to worry about that.
I'm sorry, I have a what?
A liability finding.
You don't have to worry about establishing a prima facie. You're good.
All right.
Thank you, Your Honor.
Why don't you have a seat and we'll just hear from the appellant. You have a minute.
Yes, I think I have 1 minute.
You do.
Just very briefly, Your Honor, and thank you for the time. The only brief points I'd like to make is one, with regard to counsel's reference to Rodriguez. Obviously, Rodriguez does not do away with considerations of comparative fault.
Of course.
Of course. The only other thing is, obviously, as Your Honor's correctly pointed out, the photos are not as clear-cut as counsel attempts to make them out to be. At the very least, conflicting affidavits between the parties, the notations in the police report, the photographs, the dash camera video, there are just way too many questions of fact, at the very least on comparative fault, to warrant a reversal of the lower court's decision. Thank you very much, Your
Thank you
Honors.
both.
Thank you.
Have a nice afternoon. OKL Holdings.
Good afternoon, Your Honors. Morel Berkowitz, Galadriel and Berkey, or Plaintiff Appellant, OKL Holdings. This appeal concerns the frivolous contention in support of a motion to dismiss made by a commercial lease tenant that somehow it was exempt from its obligations, from its own intentional failure to sign a consent that all other parties duly executed. The doctrine of prevention, that you cannot use your own conduct to claim some failure of the other.
Doctrine of prevention, the way I read it is you're compelling the other side, Abercrombie and Fitch, to sign a document, right?
Nope, not saying that at all.
What was, I mean, it would be.
Their whole position is that we didn't sign the consent, therefore the sublease is ineffective, we're not obligated, have a nice day.
Yeah.
So they are claiming, but the reason why they didn't sign it is they intentionally refused to sign it, and they didn't give an excuse for doing that until 5 months later, which was too late under the documents. And I'm just going to give you brief references to the record, because it really is black and white, Judge. First of all, the sublease itself was signed on May 12, 2022, and it's at pages 31 to 46 of the record.
Right, but
I only need.
No.
I'm going to answer you.
The validity of the sublease flows from the consent, though. Without that, you don't have.
I'm just giving you the dates of the documents, Judge,
Okay.
because you'll see it. I just need another 2 minutes, I promise.
Okay.
I will answer your question. You'll see it. It's plain as day, Judge.
Counsel, though, you should be answering our question now, which is how the prevention doctrine.
All right, the answer is they
or
never
not applicable in this case.
they
That's
never-
what
Wait,
we
wait,
have to
wait,
grapple
let-
I'm
with.
sorry. Start again, Judge.
That's what we have to decide, whether or not the prevention doctrine, which is really the only argument,
No
is or is not
question.
applicable. So why don't you focus on whether it is or is not applicable rather than giving us a timeline? We're familiar with the record.
Okay. The specific documentation in the record, I'll summarize it first, and then I'll give you the page references in the limited time that I have. What happened here is that we were in my client was in litigation trying to get.
Counsel, let's say they said, we're not signing the consent.
Okay, but they
Not
never
signing-
said.
Oh, they didn't sign the consent. The question is whether you can use a prevention document to force someone to sign something they don't want to sign.
Fair enough.
That's the question.
Okay. Instead of saying we won't sign this, there's communications in July of 2022 where they said, we'll only sign it if you agree to modify the lease to now have a specific cutoff date when you give us possession. That was never agreed to, because the whole point of this.
Counsel, you're not answering the question I think we're trying to ask. So it's assuming everything you're saying is true, whatever the motivation was for not signing the consent, can you use the prevention doctrine to basically force them to sign a document they don't want to sign? Is that how the prevention doctrine can be used?
If the reason why the consent wasn't signed was because they intentionally avoided not signing it, even though everyone else signed it, and the first thing they said is first modify the lease. We didn't do that.
So in other words, Counselor, what you're telling us, or telling this panel, that we can write into the consent a condition that doesn't exist.
No.
But that's
not
what
at
you're
all.
saying. You're saying that that's what the prevention doctrine, without the prevention doctrine, you're out of luck, okay? So you're using the prevention doctrine in this instance to impose a condition that doesn't exist, that could have been freely negotiated in that consent agreement or somewhere else.
My argument is much more simple, Judge. They both said sophisticated lawyers and parties. Page 44 of the lease, paragraph 9.
You're not relying on the prevention doctrine? Is that?
I am relying on the prevention, but I'm trying to rely on the record to justify it. And I only need a minute.
Okay.
Just give you the page references.
Go ahead.
Trust me, I've been doing this a couple of years, Judge. Would not make
So
a
have we. So have we, yeah.
I know.
A lot of years.
We've been doing it for a
I've
couple of years, too.
I've appeared before most of you. In fact, I've done trials before several of you, which I'm sure you won't forget. So paragraph 19B of the lease, page 44. It's the key to this case. It answers all your questions. That's a pretty bold statement. What it specifically says, I won't waste time reading it, it's in the record, it's page 44. It specifically says you have a limited amount of time. First of all, you could cancel a lease for no reason. Can't get better than that. But you have to do it before we send you the signed consents. And you can only cancel it within 60 days of the date of the lease. The lease is dated May 12th. The first time they tried to cancel it or give a specific reason, we never signed it, therefore we're not bound by it, is on December, just let me, see, my eyes are getting worse here, Judge. It's a notice of cancellation sent on December 16th, 2022. I checked the calendar before I came into court. That's 5 months that they, for the first time, tried to cancel the lease. It's too late. So aside from everything else, they didn't effectively cancel the lease.
Your minute's up. Here's my question now. I'm looking at the same paragraph, paragraph 19B, right? So that has a situation in there where if the landlord and the tenant, landlord or the tenant, doesn't sign, and that tells, and it says right here, at that point, you have, somebody has to do reasonable efforts to go and get them to sign it, right? And then if that doesn't happen, you got the 60 days kick in and all that. If they actually consent, you've got the 60 days. The problem that I have here is that you don't have Abercrombie and Fitch's signature here. So none of that 60 days kick in.
It's easy to have misread this. What has to happen is not.
I didn't write this. You guys wrote it.
I didn't negotiate it, but I can read the English as you
Yeah, so
well
can I.
can. Is that what has to be done within the time period is that my client has to sign the consent and the overlandlord has to sign the consent. And that was done in July of 2022, and it's very simple. We sent them copies of the signed consents by everybody else 3 times. And that was done, it's on page 232 to 233 of the record, and 176 of the record. I sent it to their lawyer once after it was already sent twice by the business people. So they already had, the only thing that had to be provided was us providing the consents of the others. So their time to challenge it or to cancel the lease was up in May. They didn't attempt to do it until December, and we rejected that. And then we provided possession, which took me 9 months, which is a record time to evict a commercial tenant in Manhattan. In February of 2023, we tendered possession, and they ignored it. They said we canceled it.
Okay, let's hear from the respondent. You'll have a couple minutes for rebuttal. Thank you.
Good afternoon, Your Honors.
Good afternoon.
Eric Aronson on behalf of Abercrombie and Fitch. Justice Singh, let me answer the question that counsel didn't. OKL is seeking to achieve through the doctrine of prevention what it can't in the negotiation of the contract, which is it's seeking to impose relief that the contract doesn't provide for. The answer to your question is the case, the Con Ed case that we cited in our opinions that says that the doctrine of prevention is an implied doctrine, just like the duty of good faith and fair dealing, and that it cannot be used to rewrite a contract that was negotiated by sophisticated parties. We don't think this is a doctrine of prevention case. We think that this case is controlled by Oppenheimer, among others. We think it's a basic contract interpretation case. We think the sublease says what it says.
How about the argument, which I hadn't focused on because I was focusing on the prevention doctrine, is with respect to the 60 days. How does that play in? Because they're saying essentially it's untimely what you did.
First, it doesn't change the language of the contract that says the contract, the sublease itself is not effective until there's a fully executed landlord's consent, which is a separate contract, and fully executed means what
It's a condition proceeding. We don't get to B unless you get through A, right? I mean,
right. I think Justice Lang, I think you said it, right, when you talked about if there's a,
it would be, the doctrine of prevention would be if Abercrombie and Fitch were to say, I'm trying to sign it, but these guys aren't letting me sign. They keep pulling the paper away when I put the pen down.
I would suggest it as if we caused the overlandlord not to sign it, right? If we said to the overlandlord, no, don't sign it, we'll rent another place, and then we defended a breach by saying, hey, the overlandlord didn't sign the consent. But that didn't happen here. What's really being described here is a claim that doesn't exist at law, which is the wrongful decision not to enter a contract. Abercrombie and Fitch can sign a contract for any reason or no reason. Intent is not an element of breach of contract, and we think, Your Honors.
There's nothing in here in paragraph 19H or 19B that has a condition, or at least addresses the condition where one party doesn't want to sign. I mean, it only deals with the tenant and the overlandlord, if they don't want to sign, what the plaintiff has to do, right?
That's right. This contract, the reason that we're here is because just like counsel did on this appeal by filing a notice, perfecting an appeal on a sanctions motion as opposed to waiting for us to perfect the main appeal, they ran ahead, right? They didn't have possession of the premises. They wanted to beat certain contractual deadlines. Normally, and in practice, it would be the tenant that would sign first, and then you would send it to everybody else to get signatures. But they ran ahead, and that causes this little kerfuffle in terms of the timing, but it doesn't change the language of the contract. That's all I had to say, Your Honor. With respect to the sanctions motion.
Bottom line is, without the consent, it doesn't matter what the sublease says.
Correct. And as I think Justice Singh said, the only position in the order below and articulated here by OKL is the doctrine of prevention, and without that, the motion to dismiss should have been granted.
Oh, well, the sanctions you were going to say? I'm sorry, I cut you off. You said
I don't even think the sanctions motion deserves to be addressed. I don't think it's a close call. I think the judge below got it right.
Thank you.
I want to make myself clearer. They are claiming that because everybody didn't sign it, it's ineffective. And the reason why the law prevention applies to this is they're saying we didn't obtain the consents even of them. But you have to look at what they did. And if you just look on page 185 and 114 of the record, in July, instead of signing the consent or saying we have any objections to it, they tried to change the terms of the lease unilaterally. We weren't going to agree to a specific cutoff date. I couldn't predict how long it's going to take to evict the prior licensee. And then they didn't specifically object until 5 months later in December 22, which is on page 119 of the record. So they used their own misconduct in intentionally refusing to sign the lease because they said, oh, maybe the market's
How is that misconduct where they made a business decision, presumably, not to sign the consent because they decided they didn't want to sub.
That's a good question, but they never.
That's just not a breach.
Absolutely not. But they didn't say that. Instead, they tried to extort a new term in the underlying sublease, and they didn't cancel it till 5 months later.
How is it extortion when they can't get in? They can't. There's no.
It's extortion because they knew. First of all, the whole point of them not having a security deposit and the amount of the rent was because we were stuck litigating against a licensee who held over, and they knew all about that. We kept them apprised of every step of the way. So they negotiated terms and intentionally did not have a cutoff date. That's what they wanted to insert. They wanted
19B doesn't, 19B covers a situation where the overlandlord and the tenant doesn't sign. 19B does not cover a situation where the defendant doesn't sign.
No, I agree. But it has a provision that they could cancel. For no reason. You can't get better than that. That's the best deal around. But they didn't do that till 5 months later.
Okay. All right. We will read it over again. Thank you both very much.
Thank you very much.
People versus Samuel. Good afternoon.
Good afternoon. May it please the court. Christian Vandergeest of Freshfields Bruckhouse Daringer, appearing pro bono in conjunction with the Office of the Appellate Defender on behalf of Appellant Mr. Edward Samuel. Your Honors, without the suppression of White's and Malkina's convictions, it is reasonably possible that the jury would have reached a different result on the question of whether Mr. Samuel used a knife. And that would have been crucial here because it changed his minimum sentence from 3.5 years to 20 years. I'd like to focus on why the late Brady disclosures mattered, and I'd like to start with Ms. White's. The late disclosure of White's conviction completely vitiated Mr. Samuel's right to test her credibility. Ms. White's was the last witness of the trial, the second last day. The prosecution disclosed her conviction after direct examination. The defense immediately objected. It asked for more time to go into the facts underlying her conviction. 4 times it asked for more time to go into the facts underlying her conviction. but the court denied those applications, and the prosecution further misled the court. It told the court that Mrs. White's conviction was sealed and so not available, and that was incorrect. The court not only
Would your position be stronger if you didn't have, but for Simmons' testimony here?
Your Honor, I think Simmons was completely incredible. On the 911 call,
But isn't that a jury question? I understand that there was some inconsistencies in testimony, no question. But at trial, he did say that defendant was using his fist to hold a knife on the left side of his pants. Isn't that sufficient for the conviction? Putting aside the issues, and I agree with you, there are Brady issues here, serious Brady issues. But focus on Simmons and tell me, so it's incredible as a matter of law?
well, Your Honor, under Brady, the question is whether there's a reasonable possibility of a different outcome at trial. And so,
But doesn't Simmons hurt that position of yours?
no, Your Honor. I think the key witness here was Ms. White's. Apart from Simmons, I understand your question, Mr. Simmons, wasn't his testimony that he saw a blade or something like this. But Simmons, on the 911 call, he said he didn't see a weapon. In his police statement, he said he thought there was a gun. So I don't think...
Granted, but wasn't all that brought out? Didn't the jury have the benefit of that in assessing his testimony?
Your Honor, I think the jury disregarded Simmons' testimony. They watched the video 3 times. They listened to the 911 call twice. They listened to a readback of White's testimony. They deliberated for 2 days. They did not ask for Simmons' testimony. White's was the only credible witness here who put the knife in Mr. Samuel's hand.
So let me ask something about the Brady violations, because there was extensive testimony about those convictions. Once it was ultimately disclosed, the jury heard extensive testimony about all the details, probably more than they would have if there had not been an alleged violation in the first place. So why doesn't that overcome any possible prejudice by not disclosing the Brady?
Your Honor, there was two...
They literally heard more than.
Yes, Your Honor, there was 2 Brady violations here, Malkina and White's. As to White's, there was no discussion whatsoever. The only thing that the court allowed the defense to elicit on cross was the fact of a conviction for disorderly conduct. Disorderly conduct is not a crime of dishonesty, and the defense counsel repeatedly asked to go into the facts under Ms.
That
White's
had nothing to do with the Brady violation. That was an analysis of the type of conviction and what should or should not be disclosed. I guess what I'm saying is they wouldn't have heard any more than they did hear in the absence of the Brady violation. So how could that have changed the outcome of the case?
Well, Your Honor, I think the case law is very clear that a disclosure needs to be made in time under Brady for defense counsel to review it, use it, investigate it, look for leads for admissible evidence. That's all over the case law.
What's missing in this case? What did this defense attorney not get to do because of the timing of the Brady violations that would have changed the outcome of the trial in any real way?
If they'd received the disclosure before trial, even a month before trial when the prosecution downloaded it, they could have investigated the conviction. They could have realized that Ms. White's, as a manager of this jewelry store, was selling fake jewelry to customers. This is a crime of fraud.
Anything that was relevant came out at trial.
That was never disclosed at trial, Your Honor. Ms. White's, the facts underlying Ms. White's disorderly conduct conviction never came out. The only thing the jury knew was that she had a fact of a disorderly conduct.
Right, but I'm going in circles here. That's the same thing that would have happened even if the Brady violations or the information had been disclosed a month earlier. The court would have made the same determinations it made as to what evidence should or should not come in at the trial. It didn't make its rulings about what to allow in about the trademark counterfeiting didn't have anything to do with the timing of when that information was disclosed.
Yes, Your Honor, but that was also an error. The court cannot categorically bar cross-examination of a prosecution witness on bad acts. That's in Rouse.
You're not arguing Brady violation anymore. You're just saying that there wasn't enough cross-examination.
Well, I'm saying there's 2 errors. The court refused to allow the defense to look into this conviction, and when the defense asked to ask about the facts, they said no. So, I mean, yes, they're intertwined, but both of them are reversible errors. Both of them are constitutional errors because the refusal to allow the defense to ask about Ms. White's bad acts is a confrontation clause violation, and that it also requires reversal here. So the prosecution's made an argument in their brief, oh, the Brady doesn't matter because the court wouldn't have allowed them to testify about the bad acts anyway. But the refusal to let them testify to bad acts, that's an independent constitutional error here. And so you can't excuse the Brady error with the confrontation clause error. It just doesn't work like that. You have to assume that if they'd been allowed to look for more facts, they would have found them. They would have found that White's was selling fake jewelry, a fraudulent act, and they would have been able to ask the jury, show that to the jury, and the jury would have used that to assess her credibility.
Okay, let's hear from the respondent. You'll have a couple of minutes. Thank you.
Good afternoon, Your Honors. May it please the court, Jared Walkowitz for the people. There's no doubt the people made discovery violations and made mistakes here. We don't dispute that. We would not dispute that. What did happen here, though, is that the people and the court, to the extent possible, and there was a good extent possible here, corrected those errors.
What about their argument that there wasn't enough time to really investigate it, that if they had had this information disclosed to them earlier, they could have done a much deeper investigation about the trademark?
Well, they had 4 years after the case to file their 440 motion, and let's look at what they found in those 4 years. At trial, it was disclosed to the defense that the defendant was convicted of disorderly conduct and was arrested for trademark counterfeiting.
White was convicted.
White, yes, yes.
Defendant.
I said, I'm sorry, I apologize. Whites was convicted of disorderly conduct, and she was arrested for trademark counterfeiting. Now, we didn't even have to disclose that because the statute even says only judgments and convictions. But we gave them more, as you were alluding to, and we gave them much more.
But what about the facts? I mean, that's one violation. I think your adversary says the flip side of the coin is the inability to ask about the facts, about the bad acts themselves. Is that reversible error?
No, because he asked the court about trademark counterfeiting to go into it, which is the crime of dishonesty. The only additional information he found in 4 years was that the location was at the jewelry store. Now, one other thing about that, which is really critical about that, is that not only was it at the jewelry, not only was the location the problem, it's the way they phrased it. So what they're doing is they made an error in how they went about phrasing it to the judge, because remember, what cross-examination happens is a discretionary decision. And one of the reasons why a court can bar cross-examination, and this is cited in our brief, is because they believe a defendant could mislead the jury. And by asking about something of an arrest, which is how they in the end framed it,
You can do that without, you could just ask about the facts without asking for arrest, what happened, what was the occurrence, just a basic.
Well, Your Honor, you're absolutely right. And we even conceded in our brief, arguably, it could have came in, just asked, were you selling unlicensed jewelry or at the store? They could have asked that.
But they didn't know about that, and that goes back to the point that if there wasn't timely disclosure. Putting all that aside, does Simmons save the day here?
I don't think Simmons has to save the day. I think he can save the day with the click. I think that is an extraordinary coincidence. I think the jury, on the 911 tape, there is a click, and then the knife, when it's opened up, you hear that click. But more than that, even if you're right, Your Honor, let's just say, for example, that the location mattered, okay? What, at the end of the day, would the jury not believe it? Because once she sold fake jewelry, the question they're asking is, what is her honesty on the witness stand? And second of all, the evidence in this case was there was multiple corroborations, including the police recovering the knife.
Different issue.
I understand that, but I just don't think.
We're talking about what occurred when the crime was committed, not what was found on him outside the store.
But we're talking about the reasonable possibility, and we're talking about the whole.
No question, he had a knife. No question. The knife was flicked, or where it made the clicking sound, even in the courtroom, as I understand it.
Right, but Your Honor, if I can just get back for 1 second, with Malkina, we gave them 50 pages with her testimony, 50 pages of discovery that they would not have gotten if we made a mistake. Now, does that excuse our error? No, but the law is, did they have a meaningful opportunity to use this information? And they had the meaningful opportunity because they were able to say that this person was arrested for trademark counterfeiting, and they made that application, and the court denied that application. They were then able to use that information as to Malkina and cross-examine her about the fact that she had a Medicaid fraud conviction. It was a significant one. And to answer your question, Judge Singh, they obviously credited Malkina even though she had this huge, significant Medicaid fraud conviction. So, you know, the fact that there's not only do you get the meaningful opportunity, the other side has to show that there was a reasonable possibility that this would have affected the verdict. And there's no possible way that they could do that with either Whites or Malkina because of the information that they got, that they were able to use. And thank God here the court gave them that time, they gave them that night to go over the 50 pages, they adjourned the case.
And they did indicate that that they didn't need any more time, correct?
Correct. They indicated right there that they didn't need any more time. And as I said, like, I would just ask this court to recognize that while we absolutely made a mistake, and I totally get that, and we shouldn't make this mistake, this was corrected. And that's, Brady is not, Brady is more than, did you not turn it over? Brady is there, did they have a meaningful opportunity to use the material once you made the disclosure? And Brady is there a reasonable possibility the verdict would change? And there's no legal remedy here because the court and the people corrected it to the extent that Brady doesn't allow a remedy here. Thank you very much.
Thank you.
Your Honors, this was not corrected. And I want to focus on White's again. This came out minutes before White's cross-examination. Defense counsel immediately asked for more time. Can we investigate the bad acts here? We have a right to cross-examine prosecution witnesses on bad acts. And they were not allowed that opportunity. They asked 4 times, and they asked to look at the facts. And Mrs. White was unimpeached. She sat on the stand, and she was presented by the prosecution as a manager of this jewelry store, someone who was very credible. If the defense had been able to cross White's and say, you sold fake jewelry to your customers as a manager of this jewelry store, you committed fraudulent
But there were other witnesses. See, that's and I understand what you're saying. I hear you, but there were other witnesses who testified. Malika, and she testified to it, and then of course we've already discussed it.
Your Honor, Malkina said she didn't see a knife. There's no knife on any of the three videos. There's three cameras here. None of them show a knife. Simmons said on his 911 call, "I didn't see it."
But
White's was the
what
only
about
one.
the situation about the sound, the clicking sound being on the 911 call, and the fact that when it was opened in the courtroom, the clicking sound was similar? I mean, you know, that we have to look at everything together, not just this one thing completely isolated.
So we have White's and we have the click. And I'm glad you raised the click because the prosecution mentions this like 12 times in their brief. The click was mentioned, this theory came out from the prosecution on the first time in summation. They had Simmons on the stand. They never asked him about the click. Simmons said in his police report that he thought the click sounded like a gun. And then in summation, all of a sudden, the prosecution saying, well, the click was the click of the knife opening. Why didn't they ask
Wasn't that
Simmons?
displayed? I thought the testimony was that the police officer did it, and there was, even though it's not on the record, but there was an acknowledgement that there was a clicking.
Yes, Your Honor, the knife made a clicking noise when it was opened, but it was not opened in front of Simmons. No one asked Simmons, is this the click that you heard? The prosecution called him. They asked him lots of questions. They never asked him that. And then in summation, for the first time, they brought out this theory, oh, Mr. Simmons heard a click that he said sounded like a gun, but it was actually this knife. And Mr. Simmons never testified to that. It was completely improper, and they could, and that's also in our brief, it was an error for the court to let them do that, and we objected to that during the summation.
Okay, thank you. Counsel, I know that you are doing this pro bono in conjunction with the Office of the Appellate Defender, and we would like to thank you for doing that. We would like you to thank your firm, Freshfields Bruckhouse, for permitting you to do that. You did a great job. You did a great job, and thank you very much for your time and effort on your behalf.
Thank you, Your Honor.
The next case for argument is Bayman Industries versus Empire City Subway.
Good afternoon, Your Honors. May it please the Court, Brett Zinner from the firm of Rosenberg, Fortuna, and Laitman. Bayman's quasi-contractual claims in this action are supported by the...
I'm a little, maybe I missed it, but you won, your client was a successful bidder for this milling work, correct?
Correct.
Okay. Was that under the JB 40 process protocol in terms of these utility interference work? So I thought there's a statute out there now that talks about joint bidding process when it comes to this kind of work, no? Or no?
I'm not sure about the process, Your Honor.
Okay, so this contract that you did bid on and you were successful on, did it have a component in there for utility interference work?
To the extent that the contract states that the parties who own any manholes within the roads, those are the parties who need to adjust those manholes. So that's the interference work where the contract obligates the companies who own these appurtenances to adjust them.
Okay.
Okay. So Bayman's quasi-contractual claims are supported by the historic common law obligation, which obligates a private utility company to protect their own manholes or other
Can I
facilities.
ask you a question about that? In terms of your quasi-contract claims, is there an allegation that when you reached out to the utility, that they maybe suggested, maybe will do it, something like that, which will give more meat on the bones to what you're asserting? Wasn't there a response? No, we don't have anything to do with it.
No, that's not the case, Your Honor. I think there may
Well,
be...
what does your complaint allege?
The complaint alleges that before the work commenced, Bayman and Verizon entered into negotiations, and Verizon agreed to pay Bayman for the fair value of the work.
But wait, stop. I mean, I know I think I remember that there were negotiations, but you never agreed on any amount or anything like that.
That's correct.
Did they ever specifically say, we're going to pay you something, or were you just negotiating?
The allegation in the complaint is that they negotiated and that Verizon agreed to pay the fair value of the services. You're correct, Your Honor, that there was no agreement as to the price, and that's why this claim was brought in theories of quasi-contract as opposed to a breach of contract claim. Okay, so, Your Honor, in a case that was handed down 4 months ago, the Supreme Court, Justice Bodie in Kings County determined...
Yeah, we're familiar with the cases. Yes. So you're really limiting your appeal then to the quasi-contract claims? Would that be a fair statement?
Yes, Your Honor, but there are three underpinnings for the quasi-contract claim. There's the common law obligation, there's a statutory obligation, and the third part, which Verizon doesn't address in its brief, is that this allegation that they agreed to pay Bayman, that in and of itself, under just general quasi-contractual theories, is a basis for liability.
So let's go to the common law obligation. Isn't, under our more recent case law, while there is a common law duty to pay for interference work, can your client unilaterally impose that duty? Because isn't that what you're essentially trying to do here, at least?
So if you're talking about just the common law obligation, no, of course, that's the holding in Dragonetti. You can,
right.
Dragonetti
So it's
stands
really,
for the proposition.
there's no common law basis for it. So it's really what you're arguing, and I'd like to see that in your complaint, that Verizon agreed to pay for the services.
That's one of the bases, Your Honor, but their common law is certainly a basis for liability here, because under the holding in Dragonetti, Dragonetti is really aimed at determining whether there's interference, and Dragonetti stands for the proposition that either the city has to agree it's interference or the private utility company has to agree it's interference. It can't just be the contractor who's unilaterally
And you're
determining
saying the
what's
utility
interference.
agreed to it?
I'm saying the utility agreed to it. That's the allegation. This is a motion to dismiss. It should have been deemed true for purposes of the complaint. And the city contract also provides that whoever owns the manholes for private utility manholes has to do the work. So you have the city contract saying it.
City contract. Where in the city contract with you?
Yes.
Where does it say it in the contract?
So on page 260 of the record, the highway specifications, it's section 1.06.48. It specifically states that the parties who own the manholes, those are the parties who should be adjusting the manholes. Okay.
Is there a specific reference in the contract to the section you just cited?
I'm sorry?
Is there a specific reference to the standard highway specifications you're discussing? Is there a specific reference in the contract?
Yes, it's in section D 14, I believe, Your Honor, where they incorporate the highway specification.
In general? I'm saying, was there a specific reference to this section?
It doesn't specifically but it references it in general.
That answers my question.
And Justice Bodie, Your Honor, determined that both the common law obligation applies and the statutory obligation applies, and that's based on the same identical set of facts here, same pleading, same allegations, same causes of action, same city contracts, and determined that the argument that the city contract somehow precludes
I just thought in that case, the defendants, National Grid, actually acknowledged their obligation to pay for the work, and I didn't think we had that in this case.
Well, Your Honor, we're only in the pleading stage here, so the only thing we have is an allegation that Verizon agreed to pay for the work. So we do have that in
You
this
say
case.
how much they agreed to pay?
They didn't say that. It's a quasi-contract claim. It comes down to just the fair value. And that's why I'm bringing a quasi-contract claim to ultimately determine what the fair value is at trial. So, you know, the Dragonetti exception here that counsel is relying upon, it doesn't apply because in Dragonetti, the contract didn't say that the private utility company has to pay. In fact, it said that the private utility company gets to determine whether it's interference.
Okay, the red light does mean you're supposed to stop and that's start some new things. So I know you'd like to talk more, but let's hear from the respondent. You'll have a few minutes to reply. Thank you very much.
Thank you. May it please the court. I'm Alan Kaplan from Herrick Feinstein for the respondents in this case. Justice Ong, let me answer your questions.
Thank you.
This was not a JB contract. It wasn't, recently JB 4.0 was upheld. This wasn't JB 1.0. It wasn't JB 2.0. It wasn't a JB contract. If it's not a JB contract, two things have to happen before you get a utility involved. One is you have to have Section U.
Yes.
Section U.
Is that a separate section of the contract?
It's part of the contract, but it's a separate section.
But it wasn't part of this contract,
It was
correct?
not part of this
So
contract.
that's Dragonetti, but what I'm hearing from your adversary, and I'd like you to respond, which he's really focusing on his quasi-contract claims. The first important allegation he makes is that Verizon agreed to pay for the services. Is that borne out by the record?
No, not at all. In fact, the complaint has, it has allegations that are inconsistent, because here in paragraph 11 of the complaint, no agreed prices were set for the subject utility interference work. Paragraph 16, defendants have failed and refused to justly compensate plaintiff for any of the utility
Well, does it
interference work
say that Verizon agreed to pay for the services?
It says in paragraph 10, defendants agreed and were otherwise obligated to compensate plaintiff for the labor, materials, et cetera. In the motion, they submitted an affidavit from their president, Mr. Lizza. Mr. Lizza could have made the record very clear, and he did, but it doesn't help them, because what Mr. Lizza said is that the only time prices were discussed was after the work was completed and 3 months after the lawsuit had been commenced. And the email exchanges were not between the construction people, they were between the lawyer representing Bayman in the lawsuit and in-house lawyers for Verizon.
Counsel, let me back up. With the Section U that it's required, the Section U wasn't part of this contract. Section U talks about the utility interference work, right?
Absolutely.
That's where it's covered.
That's correct.
And because it's not in the contract, I don't have to pay anything.
There's no requirement. There's absolutely no requirement.
Because this is a contract that's bidded from the city. The city has, you know, you're bidding with the city. They would have to include the Section U, and if you're bidding on it and it doesn't have it, arguably you would like, wait a minute, what's going on? How am I gonna, who's gonna pay for this other work?
I agree. And the city could have made this a Section U contract if they wanted. And in addition to that, the city...
Or the bidding person would have at least said, I'm not bidding on this unless you...
In fact, we refer to in our brief, there was a bidding section which included them bidding on doing the hardware for the manhole covers, which they claim...
So not getting the Section U provision, now they're trying...
Correct. They're trying to do an end
backdoor.
run around not having Section U, not being a joint bid contract, not having any directives, direct orders from the city.
So that goes contrary to the allegation that you agreed allegedly in the complaint that you agreed to pay, there's no Section U.
Correct.
Where's
There would
the
be
basis
no
for this?
reason for my client to have done anything.
So counsel says, well, he alleged in his complaint, and this is a 3211 motion, he alleged in his complaint that you had said that you would pay something. Now, did you put in something definitively in your motion to dismiss? They said, we never agreed to anything, therefore there's none of these causes of action.
Yes, that was the basis
That
of
was
our,
fi- that was
of our
a sworn
lawsuit. I
affidavit.
mean, of our defense.
So the fact that he said it, you know, he put that complaint, it can, even on a motion to dismiss, you're allowed to put in an affidavit that states definitively that's not what you said. And you never reached any kind of an agreement so that it could fit into the case like Judge Bodie decided in Brooklyn.
The standard is it has to be more than a legal conclusion. It has to be a fact-based allegation.
Your
And that's
back-
not what we have here.
Your backup is you point back to the fact that the absence of the Section U in the contract.
Absolutely.
That's,
Absolutely.
That's how it allows us to say, no, we never agreed to that.
It puts it right within the gambit of Dragonetti. In fact, this pleading was drafted by the same law firm that drafted Dragonetti. The same three quasi-theories of contract, and then the erroneous interpretation of the common law, which they've tried to kind of wiggle around since then. The only reason why Dragonetti was decided first, just as by way of background, it was fast-tracked because it was in the commercial division and Bayman wasn't. So Dragonetti went through Justice Cohn, then it went
That's
through
correct.
the First
I
Department,
was on that,
a bench
yes.
that Your Honor was a part of, and then this case came before Justice Ramsor, whose decision we put in, and she got it right on all accounts.
She did the whole thing on the record. She obviously relied on Dragonetti.
Correct. And if there aren't any further questions,
Thanks for clearing up the J before.
thank you. And I think that was a great decision, by the way. Thank you.
Counsel, you have 2 minutes.
First, I want to say that it is absolutely false that there was any refutation by Verizon contradicting the claim that there was an agreement as
Okay,
to...
let me stop you there for a second. What I heard is your client put in an affidavit. Did your client, in his affidavit, but because it's perfectly permissible under our law, lay out what happened with respect to why there's a quasi-contract claim? I spoke to Verizon, they agreed to pay, et cetera, et cetera. Anything like that in the affidavit?
Yes,
Your facts? Are there
Yes,
any
Your Honor,
facts?
but yes, there was an affidavit talking about an agreement they had at some point.
Any facts about it? Because as you know, legal conclusions, even on
Yes,
3211A7, aren't sufficient.
Yes, there are facts alleging that there was an agreement. There's even a discussion about what the pricing would be at that time. But that's not the sole basis, the sole factual underpinning there. There's more to it. We didn't even get to summary. We didn't get to discovery here. But counsel is incorrect in stating that they rejected or submitted evidence to refute the allegation that there was an agreement. They didn't reject. You will not find it anywhere in the record.
So I'm letting you explain this. How do you explain the Section U absence in the contract?
Okay. So while Section U is one way for the contractor
It is the
and utility to do it, it is not the only way, Your Honor. Even counsel's brief says that it is almost uniformly used. It's not always uniformly used, Your Honor.
Did your client who submitted the affidavit explain why this contract didn't have a Section U in it?
Well, Your Honor, again, this was a motion to dismiss.
Yeah, but you're allowed to flesh out the complaint. You got a motion to dismiss.
Yeah, well, we would like to take a discovery of city employees who, I know what the answer is, I know what it is, but it's not in the record. But the truth is, you know, there are differences when there's a when and where contract where you don't know exactly what streets are going to be used and you don't have the sites ready that
Counsel, you know, having sat on the other utility interference case, you had to know when you bid for this contract, if it's milling work there and it doesn't have any conditions in there for utility interference work, doesn't that cause you to pause or your client to pause and, or at least on the motion to dismiss, explain his affidavit why he went ahead without this utility interference work included in the contract?
Well, I think it's inherent in the concept that there were negotiations beforehand and Verizon says, we're going to pay you for the work. That should be sufficient.
That's for the city that you go into. Okay, I got it. Thank you.
Okay, and I just want to state that with respect to the allegation that they agreed upon it, the court rejected that allegation because of another allegation in the complaint that said that Verizon refused to pay Bayman. So, you know, in finding that allegation somehow disproved the allegation that it agreed to pay Bayman, the court didn't afford a liberal construction to the complaint or every favorable inference there.
Okay, thank you both. The next case is Lamar versus Nigro.
Good afternoon, Your Honors. Julie Steiner for the appellants. Supreme Court erred in awarding ADR benefits here because Lamar did not satisfy his steep burden of demonstrating that he was entitled to those benefits as a matter of law. It was his burden to show that a traumatic injury caused his cartilage to disappear, to cause bone-on-bone end-stage osteoarthritis of his knees.
How about with respect to the issue? I mean, it's clear there's a lot of pre-existing degenerative condition, but how about whether or not those conditions were exacerbated by any line-of-duty incident? I think that's really the issue here.
Yeah, so the board on 3 occasions reviewed his medical records, and including the new records from his 2 doctors that discuss possible exacerbation. And in each case, the board determined that it was not exacerbated because, and it went through, his 2002 MRI showing early degenerative changes. So from 16 years prior, he had this condition starting to develop. In March of 18, just after the incident, his MRI showed on his right knee osteoarthritis, cartilage wear, and degeneration, and the same in his left.
But in 2002 was when he had his first of 7 line of injury.
Correct.
Line of duty injuries. So, I mean, most people have some kind of degeneration. He started with an injury and has been having injuries for 20 years. How could that not play into it?
So if you look at the 2002 injury, which was a meniscal tear, the board looked at the records and first noted that in that MRI right after, or the x-ray right after that injury, that he had early arthrosis. Plus, the board, in reviewing the records in its numerous reports, indicated that that meniscal tear was, or that repair of that meniscal tear was a degenerative tear.
I mean, because he did, as you indicated, have a right knee arthroscopy and a partial
of his meniscal,
performed right a month after that first July.
Yes, and that's not the question, Your Honor. The question is whether the degeneration that was beginning as of 2002, how that trajectory was changed by any of these injuries. And the board, which is a panel of 3 expert physicians, looked at found
the injuries weren't the cause, but it was, I mean.
He was disabled. The board recognized that. But the board, by looking at its own physical examination of him, plus the objective medical evidence, including all the MRIs and x-rays and CT scans showing that this trajectory was because of a degenerative condition that led to bone-on-bone opposition, which did not occur, the board explained, as a result of an injury. Bone-on-bone does not occur overnight.
No.
And I can
Aware of that.
I can attest that because I'm actually having a knee replacement next week. But the point is that the board was able to determine, given that it is an expert panel of 3 physicians looking at, and the petitioner's physicians, them saying post-traumatic, it's interesting that none of them explain why it is post-traumatic other than because they are listening to what he is telling them occurred and what happened on the job. And in particular, one of his other physicians actually said in a post-operative and pre-operative report that it was simple osteoarthritis and then tried to walk that back. So it was petitioner's burden to demonstrate any exacerbation and any causation, and he did not. In fact, none of his doctors even explained anything or even considered the 2002 early arthrosis diagnosis. That was never even mentioned. Here you have the board looking at the conflicting medical evidence, and within its province was rightfully determined based on the objective credible evidence that what occurred to him was not the cause of his knee replacement, but rather his longstanding 16-year degenerative condition that ultimately led to bone-on-bone opposition, and that was the impetus for his knee replacement. Thank you, Your Honors.
Thank you.
Yes, no problem. Good afternoon, Your Honors. May it please the Court, I'm Tim McEnany of Goldberg and McEnany for the respondent. Firefighter Lamar is a surviving first responder from the trade towers.
So I want to go back to the question I asked your adversary, and the question is can we here say as a matter of law that the pre-existing degenerative condition was exacerbated by a line of duty incident? And I want you to focus on three things. One, there was a 2002 and a 2018 MRI, and also a October 2018 CT scan, all seeming to show degeneration. So how do we make that leap to find that there was an exacerbation?
So all of the doctors in this case, apart from the medical board doctors, those three doctors who sit in judgment over these applications, every treating physician said this was post-traumatic osteoarthritis, not one, not two, four, including the FDNY's own medical division doctors, Dr. Alexiadis as well. All of these doctors, including the surgeon, and the surgeon did not walk back his osteoarthritis diagnosis. That was last in their reply. The surgeon actually stated that on his first clinical exam and continues to say that even after the operation, that it was in fact post-traumatic, and he had the advantage of an operating
So you're
surgeon.
saying that there was, would you acknowledge there was degeneration or not?
Absolutely, there was degeneration. We don't deny that at all. There's always degeneration when you have trauma to a joint like this man had, and he had 7
So
traumas
you're saying
before
the
this last
trauma
time.
has caused the degeneration. So aren't you saying that it was traumatic as opposed to degenerative osteoarthritis?
When you have a trauma to a joint, it always accelerates the degeneration in that joint. It's the most commonly accepted
I
standard
understand
of
that.
orthopedic medicine.
I understand that, but are you saying it was a trauma that caused it, or was there a degenerative osteoarthritis condition that progressed down the road?
There was an underlying degenerative condition that started at least as early as his first injury to his knee, which continued and was progressive and got worse with each of the traumas to his knee. But the final straw in under Tobin versus Steisel, the Court of Appeals case, the only important one is the final one. Even if he had an underlying condition or a vulnerability, degeneration could have been massive, doesn't matter. He was capable of performing full duty right up until that last injury that he suffered. And the lower court judge got this right. He said, look, so explain to me, how is it that this man is there at a fire scene performing full duty if he was previously disabled by degenerative osteoarthritis? Well, clearly he wasn't. Clearly this was his last day. Clearly this was the last injury that resulted in an exacerbation which made it impossible for him to return to work, and he didn't decide that. He was boarded by the FDNY. The FDNY said, you can't be a fireman anymore. Your knees are just they're too compromised now. He had to have a bilateral surgery on his knees. There was no way he could ever return to work. And it was a reasonable question for that judge to ask. Given what firefighters do for a living, they basically run up and down stairwells with heavy equipment, gear, bunker pants, boots, 100 pounds of equipment on their bodies, helmets, people, hoses. How was this man surviving full duty if he was so compromised before his last day that it was only degeneration that caused his problem? It's not feasible. And the medical board doctors failed to point to anything to support their conclusion that it was purely degeneration and that trauma played no role. They don't even deny that he was injured the day that he last worked. They don't say he wasn't harmed, that he didn't hurt his knees. The man's feet fell through a floor. He fell sideways into a wall at the same time with
So
100
you're saying that in
pounds of
2002, there wasn't a diagnosis of a degenerative condition with respect to the meniscus?
Post-traumatic degenerative conditions.
Okay.
This is what the doctors see, and it's not that they're guessing or relying only on what the fireman tells them. It's from their own clinical examinations, from their review of films where they see the effusion in the joint that indicates there was trauma, the swelling that means you had an injury there.
Didn't the doctors also note that there was that they observed osteoarthritis in 2002?
All the doctors noted that he had all the doctors admit that he has osteoarthritis and has had it for a long time. That is his underlying condition. What portion of it was caused by his line of duty injuries, we can't possibly know. But what we do know is that he was capable of full duty up until that last injury, and that it was that exacerbation that made it impossible for him to return. The last injury was the cause of his bilateral knee operation, which resulted in his total disability from firefighting. So that was why he got that operation. And the FDNY paid for that operation because they connected it to his line of duty injuries. It's pretty cut and dry.
Thank you. Counsel?
Contrary to what my adversary indicates, this is not a cut and dry in terms of, well, it had.
No, the way I'm hearing is that it seems like if you have a pre-existing condition and it's just starting out, that's it. It doesn't matter if there's a line of duty injury coming on later on. The fact of the matter is, based on what I heard, is if you have that slight pre-existing injury, that's it. That's enough for the medical board to say, you know what, it's not a line of duty injury.
I don't think that's the case in every case, Your Honor. I think.
I know, but in this case, it sounds like
Well,
that's what happened.
But the thing is, the board did not just simply say, he had early arthrosis, that's the cause. The board looked at not just his 2002 MRI, but his 2018 MRI, X-rays, CT scans, and then the MRIs and X-rays that were done 7 months after the accident. If you take a look at it,
Right.
I'm sorry, Your
Oh,
Honor.
go ahead. I'm sorry. Go
If
ahead.
you take a look at it, in March 2018, after the accident, it talks about all this degeneration and all these issues. The board made note that there was no evidence of a recurrent injury or of an acute injury. Then in September, 7 months later, now it says bone-on-bone opposition, severe end stage. So in that 7-month period, all it shows is that there was a degenerative condition that progressed naturally, and not a single one of these, and it is in the board's province to look at all the medical records and determine and resolve that conflict.
I don't disagree with that. It just, to me, it sounds like, the linchpin is actually, or at least the basis is that that there was a pre-existing condition. And the question to me is, did it get worse quicker? Or did it just happen, if he had suffered none of these 7 injuries, would he still be in active duty status?
Well, the question that you're asking, Your Honor, is not a question that neither you nor I can answer. We are not the board. We are not physicians. It is the board's position to look at.
To my mother's chagrin, but yes.
It is the board's.
I get it.
You understand what I'm saying, Your Honor?
Totally.
That it's the board's province to look at these things. The other key thing that I want to point out is my adversary points to the BHS committee, the fire department. Yes, the fire department did find that he was disabled and unable to work, but they are not the board of trustees. They are not the medical board who makes we're statutorily authorized to make pension determinations, Your Honor. It's a completely different analysis, and so there is nothing in this record, not only that the BHS paid for this, there's nothing in this record, it was pointed out in a reply, but they are two completely different entities, Your Honor, and their decision has no bearing on the medical board and the board of trustees.
Got it.
Thank you, Your Honors.
Thank you. Thank you both.
Good luck on your surgery.
Yeah.
Thank you, Your Honor.
Thank you.
The next case is Kralik versus New York City Department of Housing.
Good afternoon, Your Honors. Such an honor and a privilege to argue before Your Honors. This is a unique case, Your Honors, involving succession rights for a Mitchell-Lama apartment. Not only did the appellant, Mr. Kralik, a senior citizen, live in the apartment from 2005 until now, and with his mother, who's the tenant of record, for at least 4 years before she passed away in 2009, more than satisfied.
So what about the affidavit that he put in Supreme Court, New York County, in a case against the 239 East 79th Street, where he said, I've spent pretty much, I know how the doormen act, I work and I live in this building.
Yes, Your Honor. In contrast to this,
And they do have 3 apartments.
yes, and that's what the lower court relied on, because that was really the only evidence against them in the case that in any way could support their argument that he wasn't living there. Your Honor, he had so much evidence within this case that he was living in the apartment. all of the documents, his tax documents, his voting records, his driver's license.
So you're talking about the
social-
2007, 2009 tax records?
Excuse me?
What tax records are you talking about? Are you talking about the uncertified tax returns 2007, 2009?
Yes, Your Honor.
Okay, so let's just talk about that.
Sure.
Isn't there some inconsistency, because wasn't there an affidavit also by the wife saying that she never resided there, which is inconsistent with what the tax returns say? Couldn't the hearing officer take all that into account to determine, in fact, that the records were less than probative of your client's position?
Your Honor, it was not inconsistent because it was a joint tax return, so they could only put one address on the joint tax return, so he put...
But she didn't live there, so it wasn't the truth.
Well, no, it was the truth, Your Honor.
She lived there
because-
too?
No, it was just him, Your Honor. But he couldn't say in the tax return, oh, I'm putting this address, but I just live here. She doesn't. There's no mechanism in the tax return to state that. So it was the total truth, Your Honor. And also, Your Honor, consider the fact that from 2005 to 2022, he's submitting multiple affidavits and letters stating that he's living in his mother's apartment versus
Aren't those
just
somewhat
just one affidavit submitted in 2016.
But he put himself on some of those affidavits, kind of self-serving, isn't it?
I'm sorry, what was
He put himself on the income affidavit for the Mitchell-Lama Co-op. I mean, isn't that a self-serving affidavit that he put himself on that? And I think he signed it. I'm not sure his mother even signed it. I
No,
think
he
may have
signed
had
his power of attorney because he had moved in because his mother had dementia. So he was just telling the truth, Your Honor. And within this case, the issue of whether he was living there was at issue versus that Supreme Court case. It wasn't even an issue of who was living there.
So which is that a lie then? I hate to be harsh. Is that a mistake in his affidavit saying that he was living in 2016? That
Yes.
I spend my life in the building. In addition to work there, I also live in apartment 11.
Yes, it was an error.
Is it an error or is it a lie?
It was an error, Your Honor.
Why can't the hearing officer, again, consider that and come to his or her own, to its own determination on that?
Because in this case, Your Honor, there were so many affidavits submitted in this case versus that one affidavit, so many, a preponderance of evidence showing that he's living there. But I also want to move on because my time is short. Your
Well, actually, your time is over.
Can I
as
make
opposed
one
to
quick?
short.
Can I
Yep.
make
You
one
have
quick
30
point?
seconds.
Thank you. So one of the keys here that makes this case unique is that the co-op approved his application for succession in 2017. It was entitled Stock Change, and they specifically stated, please complete the enclosed application and return as soon as possible with a $50 money order payable to Tudor Realty Services. Upon receipt, the stock change request will be submitted to HPD for final review and approval. So they approved his application based on the powerful evidence that he submitted, and this court stated in Porter v. New York City Housing Authority, which is similar housing authority, New York City Housing Authority, which is analogous, that if a co-op gives their implicit or explicit consent to a succession application, they are bound by that. So
Okay.
this co-op...
Let's hear from, I believe Tri-Faith showed up, right?
Yes, they
Late. You're supposed to come in when the calendar is called. You want to speak for a couple, I gave you 2 minutes. You want to speak first? I'll speak. Okay, HPD, you speak first? Okay. All right, you have 4 minutes.
Thank you, Your Honors. May it please the court, Hannah Sorokin on behalf of HPD. Your Honors are correct in pointing out the most significant piece of evidence in this case is Mr. Kralich's own prior unambiguous sworn statement, not only that he worked in the 79th Street building, but also that he lived there. He was very clear in that statement that
He says it was a mistake.
That's a very self-serving statement to raise after the fact, and there's nothing ambiguous about the prior statement. And in fact, in addition to saying, again, unambiguously that in addition to working in the building, he also had lived there since 1984, he also, later in that same statement, referred to harm that he and his wife had suffered in, quote, our home and my place of
What about all this other evidence that he submitted in this case? The tax returns and other documentation that he put in?
And before you answer that question, I think Justice Kaplan had mentioned earlier, putting the framework that we're in here, this is an Article 78 challenging a hearing officer's determination as to that he was not entitled to succession rights, right? So it's an arbitrary and capricious standard that we're looking at, whether or not there was any evidence there for the hearing officer to arrive at that. So I just want to put that framework in mind here, right? When you
Correct.
answer Justice Kaplan's
And that's a very, very deferential standard. And here the question is just, was there any rational basis for the hearing officer to make her determination? We would posit that just on his own prior admission alone, that's sufficient rational basis. But there's also, the preponderance of the evidence standard that the hearing officer is considering is about the weight of the evidence, not just the number. And here the weight of the evidence clearly
I mean, he testified before the hearing officer, so the hearing officer is making all these assessments, credibility determinations.
correct. And there were multiple inconsistencies.
I mean, the driver's license and the voter registration, which he submitted, those actually predated when he said he even moved into the apartment.
Correct.
And I understand it was his mother's apartment, but I mean, he was married and had a dental practice in another building.
Correct, and I think it's also important in those two pieces of evidence, the voter registration, he registered in 1990, so that's over a decade after he says he moved out. So that, again, is showing that he's using his mother's apartment for, there's indication in the record as the hearing officer recognized, using it for personal benefit, including to get exemption from parking taxes, indicating that he's trying to sort of create this paper trail for potential succession without actually living there. But
He's parking in the Mitchell-Lama complex.
Correct. And there was a prior, I think from 1990, there's an affidavit from the mother talking about a sort of a mess that was created by Mr. Kralik using that spot. And even that affidavit also acknowledges that even just looking at the income tax, the income affidavits, which the appellant argues is what all the court should be looking at, the mother's sworn statement from the 90s also shows that Mr. Kralik and his wife were appearing on those income affidavits at that time when they don't even claim they ever lived there. And there's letters from the housing company that they were appearing on, reprimanding Mr. Kralik for appearing.
The final argument made by your adversary was that Tri-Faith consented to the succession. Is that the end of it, or does HPD have some other statutory obligation?
It's not the end of it at all. I'd point first to the fact that there's nothing in this record that indicates consent from the housing company.
We heard what counsel read. So.
If I may, Your Honor, what counsel read was an invitation to submit the application and the fee for the stock change certificate, and then the next page was the application itself, but also the language there is clear that the next step and the next required step, and the law here is very clear, is that HPD must review and...
So this wasn't really a conditional acceptance, this was just a step along the way. Send this application, send your money, and we'll review your application.
Correct. I would argue it wasn't an acceptance at all, but even if it was, it doesn't matter in the grand scheme of things because the law is clear that HPD must approve, and that's clearly not the case here.
Okay.
Thank you
very much. Now, counsel will hear from you. I gave you 2 minutes.
Thank you, Your
So
Honors.
did you approve, I'm sorry, why don't you say your name? I apologize.
Thank you, Your Honors. Derek Gang from County Hurley Getty Freeman on behalf of the respondent Tri-Faith Housing Company.
So did you believe that you ever consented to this and just said, it's fine with us? Did you agree?
Absolutely not, Judge. And the housing company does not have any authority to do so. The Mitchell-Lama laws are very clear that only HPD has the authority to grant succession rights. And based on the very fine reading from the Appellate's counsel, it's very clear that there's at no point in that 2017 document that ever conveyed secession rights or acknowledged
Because I
secession.
did hear at the end his tagline that he was finishing the sentence as subject to HPD's consent, approval.
And
So
correct,
even if
Judge.
you did approve it, you know what? It doesn't mean it's meaningless until HPD stamps it and says, okay. I did hear that at the end when he was reading it.
And Your Honor, it's very clear from the record that the housing company sent letters to Mr. Kralik in 2006, 2007, and 2009, admonishing him for falsifying income affidavits, informing him that there are unauthorized occupants in the unit, and telling him that the housing company does not recognize him as a successor to the unit. So at no point in the record
And this was all before the hearing officer. This is all, he had all this in front of him.
all of these documents are submitted before the hearing officer, Your Honor. Thank you.
Thank you.
Just some very quick points. First, Justice Owing, there was no testimony before the hearing officer. It's all done on submission. So the hearing officer just looks at the documents, which
Okay, but it's still an arbitrary and capricious
Thank
standard,
you.
right?
Yes,
Yeah,
thank.
okay.
And just to address another point, so when they send him the 2017 application, this is key, and they say they're going to forward it to HPD. Under the law, under the Mitchell-Lama regulations, when the co-op gets an application, they have 30 days to either reject the application and tell the application.
But let's get to the.
Right, or give it to HPD for approval.
Right.
Right, so they chose not to reject
Okay.
it. So when they give it to HPD, it's just a rubber stamp, Your Honor. HPD just has, the reason they're looking at it is to see if there's just fraud or abuse.
Did you get HPD approval then?
No, nobody ever responded, Your Honor. And the laws, the regs don't even have a procedure. If HPD denies it, there's no procedure to appeal from that. One can only appeal if the co-op rejects the application. So that shows, Your Honor, that HPD just rubber stamps it. Also, the last thing, my colleague for the co-op.
Are you suggesting that HPD does not have an independent obligation to enforce the Mitchell-Lama law?
They do, Your Honor.
So then why is it a rubber stamp? Why wouldn't they go scrutinize the documents, make a determination as to whether there's validity to the documents or not?
Because I'm just telling Your Honor respectfully what their standard practice is.
I don't know about standard practice. I'm asking if they have the obligation to enforce the law, shouldn't they be looking at the documents?
Well, they did not do that here, Your Honor, and they chose not to do that in this case. And lastly, Your Honor, I want to point out, my colleague said that in the record that there was communication from the co-op to our client over the years denying the succession claim. It's actually the opposite, Your Honor. That the documents showed that they led him to believe that he could succeed to the apartment, and their letter, one of the letters they submitted said, "Dear Mr. Kralik," they addressed it to him, "you're illegally subletting the apartment," basically acknowledging that he's the tenant of record, and they're claiming that he's illegally subletting. And they also accepted his maintenance from 2005 to 2022 without any problem. And also, it's outside the record, Your Honor. My other colleagues claim that he put himself on income affidavits from the 1990s. There's no income affidavits from the 1990s in the record.
Okay.
Thank you, Your Honor.
Thank you all. The next case for argument is Dong versus Cruz Marte. Good afternoon.
Good afternoon, Your Honors. May it please the Court. Stephen Saul, Marshall Dennehy for Defendant Appellant Delvin Cruz Marte. Your Honors, this case is a relatively simple motor vehicle incident. Mr. Cruz Marte is operating his tractor trailer in the middle lane of a New York Avenue. He is operating within his lane. He's operating within the speed limit. He is doing everything reasonably and appropriately. And unfortunately,
That's the rub, right? Whether he's doing everything reasonably and appropriately. So let's go over it.
Yes, Your Honor.
He sees the bicycle 3 to 4 car lengths in front of him. He sees a double parked car, and I guess he believes that the bicyclist is going to stop or do something. Doesn't he have? Shouldn't he have done something? Couldn't he have slowed down? Couldn't he have moved over to the other lane? There are 3 lanes on Broadway. to anticipate what this bicyclist is going to do?
Well, respectfully, Your Honor, I think the question is between what he could have done and what he should have done and what he's required to do, what his duty is under the law.
I'm talking about under the law.
He has the ability, it is axiomatic in the law that a motorist is allowed to assume that the other vehicles on the road and the operators are going to abide by the vehicle and traffic law. To ask Mr. Cruz Marte, when he's operating within his lane, reasonably and within the speed limit, to vacate his lane because there is another motorist in an adjacent lane that may fail to see what he should see in front of him and fail to stop and
Do you
slow.
acknowledge in the record there's an indication at least that the bicyclist, the decedent, raised his left hand? Well, hold, let me finish. Acknowledge that he was trying or attempting to go into that other lane.
I do not recognize that, Your Honor, respectfully. We dispute that because there is reference in the brief to the video about this gesture.
Yes.
We do not believe that is a fair representation of what was shown on the video. We believe that is
Whose motion for summary?
an inferential leap.
Whose motion for summary judgment is it?
It is defendant Delvin Cruz Marte and the company.
The inferences go in whose favor?
Correct, Your Honor. But what Delvin Cruz Marte also testified to is that he never saw any signal from the decedent bicyclist.
So wouldn't that in itself raise an issue of fact that whether or not the decedent made a signal to move into that lane or not, and what the driver of the tractor trailer should have done?
Respectfully, Your Honor, I would say no, because we're just looking at a video. So how that gesture is interpreted, Mr. Cruz Marte says, I saw no hand signals of any kind from the bicyclist. So we don't even know. Mr. Cruz Marte, he's supposed to keep a peripheral vision. Vehicles in front of him, left, right, what's in front of him. So he's doing more than just obviously looking at this one potential bicyclist that's to his right and viewing all his different mirrors on a tractor trailer. We don't even know if Mr. Cruz Marte would have been looking at the decedent when this alleged gesture was made on the video.
Now, there's a lot of VTL sections that apply, but one of them, 1146A, does require every driver of a vehicle shall exercise due care to avoid colliding with any bicyclist upon any roadway and shall give warning by sounding the horn when necessary.
Yes, Your Honor. And what I submit is that he did everything reasonable. He observed the bicyclist to his right.
Did he sound his horn?
I don't believe he sounded his horn, Your Honor, but I don't believe that exclusively creates an issue of fact under 1146. The question is at that point, because even plaintiff respondent's brief concedes this all happens in the span of 2 to 3 seconds.
We understand.
So what we are asking Mr. Cruz Marte to appreciate that Mr. Zhang, the decedent, is going to fail to stop for the vehicle in front of him. Right. He's then going to swerve left instead of swerving right. And then what maneuver we're asking Mr. Cruz Marte to do?
Well, how's he going to swerve right? If he swerves right, he's going to go onto the
sidewalk.
Well,
maybe he goes between cars onto a sidewalk. We're asking Mr. Cruz Marte to predict what Mr. Zhang is going to do.
But forget about predicting what he's going to do. Doesn't he have to just sort of anticipate? Well, I realize it all happens very quickly.
Yes.
You know, some of us drive in the city too, but in that period of time, doesn't he have an obligation to do whatever he can do? And if he's not sure, which obviously, how could you know what someone else is going to do? Shouldn't he have had to like maybe just stop and wait and let him figure out what he's going to do before he gets involved?
Yes, Your Honor, and that was going to be my exact next point, is that what we're going to ask him to do in that situation, slam on his brakes in a tractor trailer and potentially create a hazard to traffic behind him.
Why not slow down a bit to see what...
But if he actually slows down, given the fact that the decedent crashed into the right rear portion of a 70-foot tractor trailer, if he slows down, that just means the decedent's going into the middle of the trailer. So then are we asking him to veer into a left lane that he has 2 to 3 seconds to make sure that he can now go into this left lane,
how about
vacate the middle lane?
How about driving defensively? Isn't that, don't we all as drivers have some sort of obligation to drive defensively?
I believe he was driving defensively in that he was in the middle lane, he was within the speed limit, he was staying within his lane, and maneuver to either suddenly brake unbeknownst to traffic behind him or veer to the left for traffic that may not expecting him to make a lane change would actually be arguably a more actionable conduct than what he did by saying, I'm in my lane, I'm staying here because I have the right of way within my lane.
Okay. Counsel for Keystone, you asked me for 2 minutes, right? You're the employer, am I right?
Yes, Your Honor.
Okay.
And good evening, may it please the court. Mario Batelli for Keystone Freight Corporation, Mystic Island Transport. I have the vicarious liability claim. My position is exactly the same as Mr. Sal explained. I asked for 2 minutes in the event that there were any questions, But Mr. Sal's argument is exactly that of the employer.
Okay.
Thank you.
Thank you. Appreciate that. Now you
I represent the plaintiff.
represent the plaintiff. Okay.
Well, may it please the court, good afternoon. Loki Youngworth Wright from Javerbaum, Morgaft, Hicks, Kahn, Wickstrom, and Sinnis, and we do represent the plaintiff and the estate in this matter.
Did you ask for 4 minutes?
4 minutes, yes.
Got it.
Thank you.
Is your position that when the driver saw the bicycle rider and saw the parked car, he should have basically just stayed still and waited for the bike to get ahead of him? Because he could see that there was a possibility that he might come out, so he should have waited for him to jump ahead. I mean, is that what you're arguing?
Yes.
That's the only way he could have prevented this, by actually like hesitating and waiting for the bike to get ahead of him and go out on the lane. So you're saying he should have, that's what he should have done?
Yes, Honor. So he either should have done that, or he also stated in his deposition that there was no one in the adjacent lane to his left. So he could have also moved over and given the bicycle more room to clear the double parked car and go
How could he
forward.
know that the bicycle rider was coming up to a car in front of him that was blocking him? How was the driver to anticipate that the bicycle rider was going to come out into his lane when he had already passed the bicycle rider?
Your Honor, he hadn't fully passed the bicycle yet because he had the cab of the truck had passed the bicycle, but he's still responsible for that trailer behind him, and that had not cleared the bicycle
The only
or
way
the
he could
parked
have
car.
prevented this from happening was if he had stopped before and let the bicycle get ahead of him. There's no other way he could have prevented this accident based on the way it happened, could he have?
So he could have stopped, yes, and he could have let the bicycle go in front of him, and that would
Is
have
there
been.
any other way he could have?
Couldn't he have
in your
gone
view,
to
stop the accident?
the left?
He could have gone to the left. He could have slowed down. He could have
How
been
about this
aware.
scenario? The driver testified he was going at a rate of speed of 25, maybe even slower. I'm just listening to the arguments. If he had sped up, maybe he would have passed the bicyclist already, because it seemed like the bicyclist hit the rear.
Yes.
So maybe the bicyclist was anticipating that he would speed up and move faster, and that didn't happen.
Yes, sure.
I mean, that's a possibility too, right?
Yes, Your Honor, that's correct as well. He could have gone faster. He could have avoided the bicycle
'Cause he
altogether.
consistently testified, I went below the 25 miles an hour. I mean, he's telling everybody that he's going slow. So the
When do you-
bicyclist.
I'm sorry, when do you say the decedent raised his left hand, indicating that he was going to go into that lane?
Yes, and that also creates an issue of fact too. If the truck driver had seen the decedent raise his left hand and what he should have done.
When do you say that happened? I mean, we were only talking about 2, 3, 4 seconds. So when are you saying that that happened?
So that happened while the cab was passing the deceiving bicyclist as they were about to approach the parked car. So he could have seen that
So I'm sorry,
prior
so
to.
that you're saying the cab had at this point passed the bicyclist?
It was passing at the time that he raised his left hand. The bicyclist and the cab were together, and he was passing the bicyclist.
So you're saying that the cab and the bike were essentially in line?
Yes.
It's
when that
physically
happened.
impossible for him to see that, because the cab is higher up than the bicycle, just based on just looking at the height of the truck.
So
it's not a car. We have to all agree that a truck they're very different from a car, right?
yes, and with respect to that, but he knew that the bicyclist was in front of him because he had seen him 3 to 4 car lengths back. So he should have been aware what the bicyclist was doing at that time as they were
Why should he
approaching
anticipate,
the
as your
car.
adversary says? I think it's a fair point. Why should he anticipate? Why shouldn't he anticipate that the decedent is going to follow the law, and what most reasonable people would do is to come to a full stop and let the truck pass?
Well, yes, and I think that the point also that Your Honor made before was that he could have been defensively driving, and he should have been aware. The VTL states a higher standard.
Does the VTL say that you have to defensively drive? Is that what the VTL says?
No, but it does say that you have to be aware of bicycles, and you have to, be aware of where they
Does it
are.
say you have to
and-
yield to a bicycle, though? Is there
I'm
anywhere in
sorry?
the VTL that says you have to yield to a bicycle?
No, but you have to be able to.
have to blow your
You
horn.
have to be aware of where they are and,
Don't you have to
Well,
blow a
it's what,
horn?
it's what,
them, yes.
well, that was one of the things, I mean, I think I read that before. Okay, I think we.
Thank
your
you.
Position, thank you.
Thank you, Your Honor.
Now, counsel, you represent the Sungs, who were that was this double-parked vehicle, am I correct?
That's correct, Your Honor. Good afternoon, may it please the court. William Healy from Carmen, Callahan, and Ingham, representing the Sung defendants. I have very little to add on as what my colleagues has stated. The underlying motion was denied correctly. This is a triable issue of fact as to whether or not the truck in this scenario exercised due care under 1146A.
If a truck is moving in the middle lane, following, under the speed limit or on the speed limit, what more should the truck have done?
The truck realized, the truck driver, per his deposition testimony, had stated that he recognized that there was that double parked car as they were crossing the prior intersection, which can be seen on the video. He knew at that point that the bicycle was also ahead of him. What he could have reasonably done or exercised what would have been reasonable due care is best left for the jury to decide in this scenario. Whether or not he should have slowed down, sped up, or moved to the left lane, which he agreed in his testimony was completely available for him to do at the time. And as such, that motion was denied correctly.
Would you agree that if it was a car and not a bicycle, there is no way that the truck would have assumed that a car would come out into his lane?
I can't agree to that because I don't know what the truck driver was going to assume. And operating a truck, which is something I personally have not done in the city of New York, and something that
Sure.
this truck driver has testified that he was even familiar with this area. What he should expect as to a car versus a bicycle is something that only he can determine, and something that has to be left for a jury to decide.
I'm listening to the arguments here, and it just, we don't know exactly what happened in the back there. What we do know is that half of the truck passed the bicyclist safely. And it was the last part, or at least the back wheel, that's where it happened. So we don't know exactly. I mean, did the bicyclist stop and then he started moving and that the truck wasn't moving fast enough? Or the bicycle never stopped and just cut it? I mean, there's just so many scenarios that happen in the back of that truck that we don't know.
Exactly, Your Honor, which is why the order from the lower court was correct herein, because it is a tribal issue of fact.
Let's hear, you have 2 minutes.
Thank you, Your Honor.
I'm not sure I would call this a simple.
Yes, very brief points. I just want to point out that we are dealing with an e-bike here. This is a propulsion e-bike as opposed to a bicyclist. I also do want to make note that, Your Honor, regarding the point as to blowing the horn, the section does state when necessary. And given Your Honor's statement,
So let's talk about it. When necessary, you have a bicyclist, a double parked car. Could a jury find that under these circumstances, a horn, especially coming from a tractor trailer, would be necessary?
I believe that would require too much predictive behavior on the part of the driver. A horn would be as if you could see a bicyclist that is about to, coming from a cross street and is going to be crossing in front of you, or you see someone begin to come out in front of you, because, to Your Honor, to your point, that could he have sped up, could he have slowed down? That would require having the forethought and the advanced knowledge of what maneuver the e-bike was going to do, because if the e-bike tried to slow down and go behind the truck at the same time the truck said, I'm going to slow down to let the e-bike, because we've all been confronted with that when you're trying to merge on or off a highway or into an exit. Both of you start slowing down, both of you start speeding up, and you can't figure out who's getting in front of behind of who. In that situation, the safest thing that Mr. Cruz-Marte could do was do what he was doing, operating reasonably, carefully,
Well, why?
within the
Why
speed
not?
limit and within his lane.
Why couldn't the jury say the safest thing he could have done was moved over? He acknowledges there's nothing in the left lane. I'm not saying that there's a requirement to do it, but why couldn't the jury consider whether he could have done that under those circumstances rather than continuing in the middle lane of Broadway?
Because he's operating safely. So for him to do an abrupt move to either slow his vehicle, he has traffic behind him. There is language in the case law in the VTL that you should not abruptly stop or slow your vehicle when there is no cause to do so. So if he believes that so he's within his lane, he has nothing directly in front of him, for him to simply stop or slow his vehicle is not something that is established in his duty under the VTL.
Okay.
Okay.
Thank you, Your Honors.
Thank you all very much, and have a nice afternoon. The next case for argument is Monson from Pong versus Forbes. Oh, no, I'm sorry. I gave 2 minutes to the defendant.
Very quickly.
In Hunt versus CubeSmart. Sorry. Go ahead.
Ready? May it please the court, my name is Lauren Bristol, and I represent the respondent, defendant respondent, CubeSmart Self-Storage. In this case, the order of the Supreme Court properly dismissed the Supreme Court action as there was another action pending. What we have here is a situation where the plaintiff was looking to double dip. She had an actual order, default order, from the Civil Court, Bronx County Small Claims Court. And when she had that in hand, a few weeks later, she decides to bring a Supreme Court action for the same facts, same circumstances, same everything, same looking for monetary damages. She commences that with just a summons and then proceeds to do order to show cause to try to get a decision on the merits.
Properly dismissed it.
Yeah, so what we have is all kinds of motion practice in both the Supreme Court and the Civil Court happening
It's
at the
undisputed, you can't have two actions pending. They have the action of small claims, you can't do it in Supreme.
Right.
That's your argument.
I mean, I think we got it.
Exactly, and everybody acknowledged that both was going on, but thank you for your time.
You're welcome. Have a nice afternoon. The next case is Manson from Pong versus Forbes, sorry.
Just for the record, bicyclists are people too.
Brings me back to my 2 years in the motor vehicle part.
May
Okay.
it please the court, Michael Zhu, appellate counsel for Morgan, Levine, and Dolan, attorneys of record for the plaintiff appellant. The lower court's order granting the defendant's motion for summary judgment dismissing the complaint should be reversed because the defendant failed to establish its prima facie burden in submitting evidence as to when the last time the stairs were inspected. The testimony from Christopher Forbes, the owner of the house, was that it was a house that he bought for his mom, and he visited.
What impact is it that it's arguably a latent defect? That
There was no evidence that it was a latent defect. There was no evidence
Well,
that.
wasn't the plaintiff herself regularly walking these steps, and other than her vague claim of shaking, she did not really state that there was anything wrong with these steps, and she had walked on it early in the day and didn't notice anything wrong.
But I'm not the moving party, it's the defendant. So the defendant has to establish that there was no evidence of a latent defect. If he's at the premises every 2 to 3 months, he can't state, I was there 4 weeks before and I saw nothing and there was nothing wrong with the staircase, then I'm not here. I would tell my client, don't take the appeal. But because the defendant testified that he's there just generally every 2 to 3 months, but never states when he was there last relative to the date of the incident, he can't establish that there's no issue as to
If a defect
whether.
is latent, that sort of means that a regular inspection schedule is not going to change it. The case law that's developed about that you cite in your brief are cases where there's debris on the floor or something on the floor, oil on the floor, that a reasonable inspection would have caught it. And that's why a latent defect arguably is a different analysis. So how do you address that?
Almost true. But the issue is, if he doesn't inspect at all, then he can't say that it was a latent defect. We don't know what the only testimony
Well, she
here.
fell through, right? When she walked earlier today, there was no hole in the steps, so.
Correct.
It wasn't like something that was debris that would have been there early in the day that someone would have seen by examining it.
I totally understand. But the issue is not the nature of the defect. The issue is whether he establishes his burden.
So I have a question. All right, to break this sort of stalemate here, what about the handyman
Not a stalemate.
Paul?
That's
not a
what
stalemate,
Plus,
Judge.
it's not a stalemate. But
I
what
never
about
win. I never win.
Well, you shouldn't say that. But anyway, what about the handyman Paul? Because she apparently said, or at least I read somewhere, where she told Paul about what was happening. There's nothing on the record from Paul, right? There's no affidavit.
No, there isn't. And they're actually.
I mean, if you're raising a factual issue, right, it wouldn't have been simple to get an affidavit from Paul saying, yeah, you know what, she told me about it. You know, I actually looked at, there is a problem here.
And it wasn't even just a made-up name, because Mr. Forbes confirmed it. saying
So where is that? I mean, that's sort of like, for me, something that could push this one way or the other, correct?
Yes, Your Honor. So, correct. Her testimony is that she felt that it was shaky. She didn't know who Paul was. She knew that Paul was someone who came to the house to fix things. So
All you gotta do is raise a factual issue, right? That's
I
what
agree,
you're doing.
Judge.
So Paul would have been it.
Yeah, and the defendant confirmed that there is a Mr.
Right.
Paul, who's a contractor that he hires to make repairs. Thank you.
Welcome.
Good afternoon, Your Honors, and may it please the Court. Sarah Pavlini of Kahanafeld for the defendant's respondents. Contrary to what plaintiff
Well, let
argues,
me flip it the other way. You're making a motion for summary judgment dismissed. You're saying it's a latent defect.
yes,
Paul's hanging around. Where's Paul's affidavit saying, you know, I go every day, you know, I go every week or whatever, and, you know, plaintiff told me about it. I looked at it, there was nothing wrong with it. Or, yeah, there was something wrong with it. Where's his affidavit?
well, ultimately that's irrelevant because the shakiness of the staircase is not the particular defect that gave rise to plaintiff's accident. What happened was this fourth step on the staircase broke down the middle without warning. She has no testimony about the staircase shaking. The law
She's not a carpenter. She's not a carpenter. She's a home health aide. I mean, the question is Paul's the guy that comes and fixes stuff at the house.
Yes.
He's a handyman.
But
They're very
it doesn't
good,
matter
actually.
because it's
Handymen
not
can fix a lot of things, I tell you.
it's not the specific defect that caused the accident. And mere notice of a general or unrelated hazard is not sufficient to establish constructive notice. So there's no evidence in this record.
Silence there was deafening, but okay.
There's no evidence in this record that the particular defect that caused the accident was visible or apparent. The record reflects that this defect only manifested itself at the moment of plaintiff's accident.
I mean, the thing is, but have you proven on your motion for summary judgment that the shaky stairs could not have indicated there's a problem with the stairs? I mean, obviously, if the hole had been there, she wouldn't walk down the stairs. But maybe the fact that the stairs were rickety or shaky indicated there was a problem with the stairs and they needed to be repaired. She says she brought that to the attention of Paul. Apparently, he didn't do anything. So how do we know it was latent and that it couldn't have been discovered had a good, a thorough investigation taken place? And shouldn't you have put in an affidavit from someone that said we didn't, you know, we checked those out and there was no way it could have been?
I have a couple of responses to that.
Okay.
And first is that this court has frequently decided as a matter of law that a reasonable inspection would not have led to discovery of the defect. That is the legal definition of what constitutes a latent defect. And evidence
But how do we know that this is one of those?
Well, evidence of the type we've submitted, that these stairs operated completely normally without any issue for the years leading up to the accident, including on the morning of the accident itself, suffices.
If Paul had fixed the shaky stairs, say put a few nails in or whatever you do to fix stairs, would that have fixed the latent defective condition?
I mean, the latent defective condition appears to be the apparent compromise to the structural integrity of this wooden step.
Just yes or no, would it have done it?
No. Additionally, I'll note that the complaints about the stairs being shaky, they're very vague in general in nature. There's not any testimony that this particular step was shaky. And I think an apt comparison for this case is the Palomo case we cite in our brief. In that case, like here, we had a plaintiff who had stepped on a marble step or a landing of a step and was injured. But there, this court found that there had been an issue of fact as to constructive notice because there was evidence that that particular step in the staircase had been visibly cracked for a sufficient length of time and that that particular step wobbled when stepped on. We don't have anything approaching that level of specificity here. We just have a general comment that the stairs sometimes shook. This is a wooden staircase in a basement in a house that was built in 1926. I don't think there's a plausible argument that this offhand comment about the staircase shaking would reasonably alert the defendants to the fact that there was an issue with this particular step. And finally, I'll just remind the court that the definition, once again, of what constitutes a latent defect is if it would be discoverable upon reasonable inspection. And here, we have documented history. This defendant testified that he inspected this home on a bi-monthly basis, which included not only a visual inspection of the stairs, but he would traverse the stairs, he would go down and up them to check on the basement, and he did not report experiencing any issues, and he testified that there were no visible signs of damage or wear and tear to these steps.
I would feel, I mean, corroborating the defendant's owner's affidavit with Mr. Paul's affidavit or something would be, you know, in my mind, something that would be part of the prima facie. But that's just, I'm thinking through this, but okay.
Thank you.
Thank you. Counsel, you have 2 minutes.
Considering the time of the day, I'm going to waive my rebuttal.
Oh, thank you.
Thank you.
And the last case for argument is People versus Williams. Good afternoon, or good evening, as the case.
Good evening, Your Honors. I'm Benjamin Weiner from the Center for Appellate Litigation on behalf of Appellant Mr. Williams. Mr. Williams is 1 month shy of his 38th birthday, and he has come an incredibly long way in the last 15 years from the time of this offense, when he was a 23-year-old young man racked by the trauma that he had experienced as a very young child. He has taken responsibility for his actions, taken responsibility for his family and his life, and we ask this court to reduce his sentence so he can be released from prison after a decade, so he can go be a responsible parent and a responsible family member in his community. Undoubtedly, this was an extremely serious offense, and we're not disputing that.
What was he facing? If he had gone to trial and had been convicted, what was he facing?
I believe he was facing life without the possibility of parole.
Yeah, 50 to life, I think, is what my notes indicate. But
Yeah.
And what did he get?
He ultimately received 12 years, Your Honor.
So it's a negotiated sentence. He's facing something much, much more seriously. How should we look at that element?
That's certainly a factor Your Honor can consider, but as Your Honor well knows, this court can reduce sentences even in cases of negotiated pleas, and there's reason to do so here. Again, this is someone who experienced extreme trauma in his youth, whose mother was so severely addicted to drugs that at 7 years old, Mr. Williams was caring for his younger siblings, and when he was just 9, he experienced a really unbelievable tragedy. His mother was shot and killed in a street altercation. That would be incredibly difficult for any child to deal with. But for Mr. Williams, someone who lacked real support systems, he couldn't even understand what had occurred, let alone process that trauma. And what is remarkable about Mr. Williams is the way that he has transcended that now as an adult. This is someone who has done the serious work of taking responsibility for his actions. His letter to the court before resentencing reflects that this is a person who takes very seriously what he did in the past, the mistakes he made in the past, and that he has determined to turn his life around after a decade in prison. I just want to commend to Your Honors the letters of support that he received.
So is his term almost up? I mean, he's almost at the 12 years, am I incorrect?
Yes, Your Honor. His current conditional release date, I believe, is March 22nd of 2025. So he is nearing the end. I believe he would be eligible for conditional release if the court does reduce his sentence to 10 years. Again, I just want to point out again, these letters of support are remarkable. They show him as someone who is able to support his family even from hundreds of miles away after decades in prison. This is the kind of person who should be released to be there for his family and his community. And he's also shown that he can be law-abiding. This is a person who had no disciplinary tickets while in a maximum security prison. I'm not just talking about avoiding violence or contraband. This is not putting a toe out of line in prison, and that is really rare and really shows that Mr. Williams is the kind of person who will be law-abiding at the time of his release. 10 years is sufficient to punish Mr. Williams. It is a long time in prison, and this is a person who has demonstrated that he has been rehabilitated, that he deserves to be released, and that he will make the most of his an opportunity for release to be there for his family. Thank you, Your Honors.
Thank you.
May it please the court, Charles Wan for the respondent. If your honors have no questions, I will rely on the arguments asserted in my brief and request an affirmance.
Oh.
Okay.
Thank you, your honors.
I'm not sure you get any rebuttal after that.
No,
kind of
thank you,
argument.
Your Honors.
All right, thank you, counsel. I appreciate that. Have a good night.
Thank you. Good night. Sorry to make you wait. Just stand up and say.